kindly. One matter, my lord, your lordship have disposed of in RPFC in Dharwad. My lord, I have filed an application for recalling that order on the ground that a notice had not been served to my client. My lord, my lord, the lordship has enhanced it. Now they have taken the coercive steps to recover the amount. And hence, my lord, I filed application for recalling as well as stay. My lord, the office says it will take some time. Matter is that Harvard office says, my lord, it will take some time to get the post since your lordship are sitting here. My lord, matter is urgency. Lordship.
Monday.
My lord,
Monday.
12th, my lord.
Yes.
Much.
Page-wise adjournment. This one, page 1, serial number 1 to 4. Page 2, 5 to 8. Page 3, 9 to 11. Page 4, serial number 12 to 15. Page 5, 16.
Madam, serial number 13, ma'am. Serial number 13. The petition will be short.
Just wait. It's for orders. It's coming. Yes.
List number 2, page 1, serial number 1 and 2. Page 2, 3 to 5. Page 3, 6 to 9. Page number 4, serial number 10 to 17.
12,
Page 5.
12 next week.
Huh?
12, serial number 12, list 2.
Rangaramu U.
Why?
12. Rangaramu U.
Respondent,
Why you want time?
P. Sharat Kumar.
B. Sharath.
Why you want time? There must be a stay in this matter. We'll just see. If required, we'll grant them. Please wait.
Page
Yes.
5, 18, 19. List number 3, page 1, serial number 1 to 3. Page 2, serial number 4 to 9. Page 3, 10 to 14.
14 minutes. I am for the appellant. 6 time minute or 2 weeks time. I have to secure some documents relating to the,
Have you informed the other side?
yes, ma'am.
With the request of the counsel for the appellate, let's just matter after 2 weeks. You are here. Yes, next.
Page,
Increment action.
page, num-
Look at it. If interim order is there,
Please.
page number 4, 15 to 19.
My lord, serial number 15, my lord, I am appearing for the respondent number 2, my lord.
Which list, sir?
yes.
Kindly have next week, my lord, I to get some records from the company, my lord.
15. Which-
Interim order is there in
which
this?
panna?
I don't think, my lord, there is no interim order, my lord. The
Request
appeal
of
has
the
been.
counsel for the respondent, let's just matter next week. Look at it. If interim order is there, extend. Have you informed the other side?
No, my lord. No, my lord.
Then why, how can you make a mention? You will come and wait here till the matter reaches.
Not having this number, madam, that is what otherwise I would have.
But you know, that's what the cause list says. That
Yes.
unless and until you inform the other side, you shouldn't make mention. Inform him now.
Yes, ma'am. Much,
Yes.
much.
List number 1, parted matter, serial number 1.
I am for the petitioner, my lord.
Guru Dutt K. Ajit H.
I am for the
Appear for
petitioner.
the respondent.
Yes.
This is
Yes,
the trans,
what
this
is-
is the white petition.
Yes, yes. What do you say?
The matter is with regard to the transfer of the suit, my lord. The thing is that they are taking a ground as she's unemployed and she couldn't travel, man. They have falsely stated in their affidavit also that she is unemployed, man. But in our counter affidavit, we have mentioned that she is working, and we have
He's working where?
in a company called
No. Which place?
in Bangalore itself,
In Bangalore, she's working. She's seeking transfer from where to where?
from Kundapura to Bangalore.
Yes, all the more reason.
More
Because
50
she's working here.
And there is one more criminal case in the Kundapura court, man. They have made
When was this MC is of which year?
22 man.
22.
Yes, ma'am.
What is the stage now?
Lordship, I am not aware of that stage, my lordship.
When did you receive
It-
notice in this MC?
It is the stage for evidence, my lord. Petitioner evidence. And she is not working, my lord. That is the wrong affidavit filed by the petitioner. This one respond, my
No,
lord.
what about the criminal case that is pending there?
Here, that case is pending. And we have filed for transfer of that petition to the, this one, quashing we have filed. It is not yet come before the court, madam.
Yes, please come.
My lords, time may be granted, my lordship. We will provide their her PF ID and other details.
So we'll accept that she's working. We'll accept that she's working.
So she is not working, my lord. That is a false submission, ma'am. Not correct.
The
They have
present
created
petition is
documents.
filed
Okay.
seeking transfer of MC number 13 of 2022 pending on the file of the Senior Civil Judge Court Kundapura to the 6th additional principal family judge, Bangalore, where the petition filed by the petitioner, that is criminal miscellaneous number 55 of 2022 is pending. The facts of the case are the marriage between the parties taken place on 25/4/2021 at Udupi. In view of the differences between the parties, the petitioner herein has filed the parties have started deciding separately. And the petitioner has filed criminal miscellaneous number 55 of 2022 on the file of the 6th additional principal family judge, Bangalore. Thereafter, on 29/1/2022, thereafter, no, don't give the date, thereafter, the husband has filed a petition under section 9 of the Hindu Marriage Act seeking restitution of conjugal rights. Now the present petition is filed seeking transfer of the said case from Kundapura to Bangalore. The reason that is, the grounds that are stated for transfer are, one, that she is unemployed, and the other is it's difficult for her to travel from Kundapura to Bangalore. What is the distance?
450 kilometers.
That's 450 kilometers. The land council appearing for the respondents of a petition submits that considering the difficulties of the inconveniences being caused to the wife who is at Bangalore, and considering the distance between both the places, the pending MC at Kundapur has to be maybe transferred to Bangalore next para. Land council for the respondent submits that the wife is gainfully employed in Bangalore, and a false submission is made before this court. There is no difficulty for her to travel, and no grounds are made out seeking transfer of pending MC from Kundapura to Bangalore. In response to that, land council appearing for the petitioner submits that, as stated by the petition, by the respondent, the wife, she's not working, and she's not working. Next para. Having heard the counsels on either side, there is a material on record. The admitted fact is that the wife is residing at Bangalore and the MC is filed at Kundapura, and the distance between both the places is about 450 kilometers. This court is not inclined to go into the aspect of whether the wife is gainfully employed or not. Even if she is gainfully employed, the distance between both the places is 450 kilometers, and it would be difficult for her to travel. Considering all this,
My lordship, on submission. There are 5 accused in that case, my lordship. Every time they are traveling regularly and they are attending the case regularly.
in which case,
In that criminal case, pending at Kundapur.
the respondent submissions, he submits that there is a criminal case filed at Kundapur, and they're attending the same. Then in response, in reply, it is submitted by the land council, the petitioner, that they've even filed a petition seeking transfer of the said case also, and the same is pending consideration before the court. And hence this court is inclined to allow this petition. Accordingly, the following, the pending criminal, the MC number 13 of 13 of 2022, pending on the file of the Senior Civil Judge Court, Kundapura is withdrawn and the same is transferred to the fifth, fourth, sixth additional Principal Judge, Bangalore. Accordingly, law.
Serial number
Much-
2, Harish Bandari T for petitioner, SR.
Yeah, the wife shall cooperate with the trial. I shall not seek unnecessary adjournments. Yes, next. What are your instructions?
Lordship, the party is present, your Lordship. I may submit, your Lordship. You find, your Lordship. The compared to your Lordship, left by her husband on 18/9/2023 at Davangere.
18,
18/9/2023 at her parental house.
what complaint?
No, petitioner.
Oh.
Petitioner was left by her husband, sorry.
Hmm.
At her parental house on 18/9/2023, your Lordship.
Hmm.
Marriage was solemnized in 2022, 5/12/2022. The legal notice was issued, your Lordship, on 29/1/2024. In fact, your Lordship, that legal notice was issued by
Legal notice dated
29/1/2024.
29/1/2024, received by you on,
Issued by your Lordship, it is not forthcoming, but I received it, your Lordship, when I was working in Bangalore office. I was working under the hybrid mode. Hybrid mode, your Lordship, that is 3 days or 4 days, 3 days here, 3 days in the work from home.
so 3 days you're here.
Yes. Now, your Lordship, particularly on the particular day when I received the notice, I was in the office. Then, your Lordship, divorce petition filed by the husband on 17/2/2024. 17. Restitution of conjugal rights, I have filed, your Lordship, on 23/2024.
Correct. But what it is, the material placed is.
One
it is on
minute,
8.
I'll come to.
There is some difference in date of filing.
We'll look into it.
As far as domestic violence is filed on 1/4/2024, your Lordship.
No, without going into all this,
Yes,
the fact remains is she's working here.
for 3 days,
So
3 days.
in the 3 days you contest the case.
Now,
for-
your Lordship, what I have given to understand, your Lordship, her job is coming to an end, your Lordship, by this month or next month.
Did she state all these facts in her affidavit?
No, at that point of time, it was not filed, your Lordship. Now she has,
She filed a petition for restitution of
yes,
conjugal rights.
yes,
And when you're saying that that is within the jurisdiction of that court, what did she say?
conjugal rights.
When she's working for 3 days in Bangalore and for 3 days she is in her place, not to harass the husband, she will file the case at that place.
No,
When
Uh,
both of them are in Bangalore, why not in Bangalore?
no, now she is in, your Lordship, may I submit, she is living in the PG. Now she has a single room, she has shifted there for 15 months back, 15 days back. Single room she has shifted. Only 3 days, 4 days, she will be here as and when the company calls. That, your Lordship, she has to leave the job by next month or another 2 months.
No, we are talking, you filed a petition
Yes,
in 2024.
yes,
Now we are in 2025. We are
Yes.
not talking about what is today.
yes, yes,
We should talk about what was it when you filed the petition.
yes.
And let's look at your restitution petition. Did you say
Yes.
all this with
Restitution.
regard to the jurisdiction? when it
Restitution
comes?
petition, in my
Let's see
petition, your
that.
Lordship, I have produced. It is,
Let's
your
see.
Lordship. Yes,
Give that the next.
that annexure B in my petition, your Lordship.
Yes, let's see.
Annexure B in my petition.
Page number.
Page number, your Lordship, 32.
So let's see. Come to the jurisdiction for the last period. What did she say? That itself is missing. Only page, para number 5. Further, it is not there. Do you
Next
have
page
it?
it is.
Next page, next page.
Next page it
It's
is.
by, probably
The
by,
cause of action for the petition has arisen since
when the respondent
this
withdraws
company
the
was
company
without
and
the lawful
petition
and the
without any lawful
petitioner family
excuse
made
action,
effort.
and the family made effort to union the
The
respondent.
residential letter stated in the
Petition residence address stated in the
Parental
cause of
home.
his parental house petitioner and respondent's marriage was solemnized so and so, Basab Kalyanamanta with the jurisdiction of this honorable court. Hence, honorable court has got jurisdiction to enter the decision. This is what she has stated, Your Lordship.
We'll transfer her case to Bangalore. Please come.
No, 3 cases are pending in Davangere, Your Lordship. 3 cases. 1 restitution of conjugal rights, 1 criminal case is pending. Therefore, yesterday I have got the news, Your Lordship, that criminal case is also stayed by the other side before this honorable court proceedings. And domestic, 3 cases pending before the Davangere. For all the 3 cases, Your Lordship, and moreover, what is she apprehends, Your Lordship, in the family court, the her husband is accompanied with her father-in-law, mother-in-law, and brother-in-law. She is afraid of them. And she's siblings are, Your Lordship, there is no male members in her family other than father. All are sisters.
So if it is there, who will come there? If she is attending the case at Davangere,
Davangere is nearby, Your Lordship. His father will
accompany her. Who will
his
accompany?
father will accompany her, Your Lordship. But he's aged man. To that extent, he can able. But traveling to Bangalore, Your Lordship, for his father.
She's an independent lady, working, doing her job. Do she require anybody to accompany her? Is the
What?
father accompanying her to Bangalore every time?
Attention, Your Lordship, that all the 3-4 peoples are
All
coming.
these, we courts can't, be a part of this kind of, the husband files a petition here, so immediately go somewhere and file a petition there.
The mere for the reason, Your Lordship, the husband has filed the petition prior to this, Your Lordship, does not mean that, Your Lordship, the ladies have not the.
That, it's not about it. It is about the fact that she is in Bangalore for 4 days.
No, 3 to 4 days in Bangalore.
Then,
Monday,
why
Monday,
should the
Tuesday,
man be
Thursday.
there?
Then she's leaving to Davangere.
Then what about, then whenever she is here, she can ask the court.
3 to 4 days, Your Lordship, she has to work in the office. She has to work in the office. Then, Your Lordship, again, in the hybrid mode, she has to work.
Nobody is compelling her to work in the hybrid mode. Is it not? Please come. The MC
And
number,
on the other hand, one pointed out what Your Lordship, yes, Your Lordship, that he has pointed out that her address, that is before the statement, before the police, he has given that residing in Bangalore. But the very complaint she has submitted, Your Lordship, her address of the Davangere only. So mere 164 statement.
we're not going to the, I'll not record that. That she is as per that.
Yes, yes.
With regard to that, I'll not record anything. The MC number 1162 of 2024 is filed by the wife seeking transfer of MC number 1162 of 2024, pending on the file of the 3rd Additional Principal Judge Family Court, Bangalore, and transferred as a case to the Family Court at Davangere. Husband has filed CP number, wife had filed CP number 250 of 2024, seeking transfer so and so. Husband had filed CP number 340 of 2024, seeking transfer of MC number
430.
162? No. What is that?
430 of 2024.
Go 134 of
134.
134 of 24.
134 of 2024, pending on the file of the Family Court.
Davangere to back.
What is the transfer you're seeking? Please
Lord.
look at, please come to your
Please,
prayer.
all these cases, my Lord, 430 and 134 pending on the file of
That will not
Davangere.
be transferred by this
Please,
court.
only MC 134 of 24 pending on the file of
So
family.
how
court.
your prayer, how can you make such a prayer? And how they have numbered your petition? Pass an order directing the transfer of proceedings under the DV Act, that is miscellaneous number so and so.
Both
And
the
proceedings
additional
under section 9 of the
JMFC
HM Act.
Davangere and proceedings under section 9 of Hindu Marriage Act on the file of Family Code Davangere in MC 134 of 24 to the Family Code Bengaluru, where MC was 1162 of 24 is pending.
So
The
he wants all the three to be transferred to your lordship to Bangalore.
petition, the prayer that is sought by the husband is to transfer criminal miscellaneous number 430 of 2024, pending on the file of the 430 civil judge and JMSC Davangere, and also MC number 134 of 2024, pending on file of the Family Court Bangalore.
Family Code Davangere to Bangalore.
In the file of the Family Court Davangere to be transferred to Bangalore, where MC number 1162 of 2024 filed by him is pending. The facts of the case are: the marriage has taken place on 5/12/2022. And it is the case of the husband that the wife had deserted him on 18/9/2023. And according to the wife, the husband had deserted her. The husband had filed the divorce proceedings on 17/2/2024. That is MC number 1162 of 2024 on the file of the Family Court Bangalore seeking divorce. Thereafter, the wife had filed on 24/2/2024. The wife had filed the complaint under section 498 of the section 498 of IPC, which is registered as crime number 21 of 2024. Then she has filed on 21/3/2024. She has filed a petition seeking restitution of conjugal rights within before the courts at Davangere. And she has also filed a petition under the Domestic Violence Act. It is the case of the wife that she's residing along with her parents at Davangere, and the other cases are pending before the courts at Davangere. As such, the matter pending before the courts at Bangalore shall be transferred to Davangere. Then then counsel for the husband submits that the wife is working in Bangalore and to harass the husband. The cases are filed at Davangere. Learn counsel for the wife does not dispute the fact that she's working here, and it is submitted that she's working in a hybrid mode. 3 to 4 days she'll be in Bangalore, and the remaining days she'll be working from home from Davangere. It is also stated that if the wife whenever the case is coming up, the husband appears before the court along with the family members, and as there were no persons here, she has to come alone, and she feels there is a threat to her. As such, the MC pending here needs to be transferred to Davangere. Next part, having heard the counsels on either side, produce the material on record. When a petition is filed by the wife seeking transfer, the court will always look at the convenience of the wife. In this particular facts and circumstances, where the wife is working in Bangalore and stating that she's working on a hybrid mode, and some days she'll be in Davangere, that cannot be a ground to file the case at Davangere. And on that ground, a case from IMC pending in Bangalore cannot be transferred to Davangere. In fact, when she's working here for 3 days or 4 days, as stated, it would be in the interest of both the parties, and balancing the interest of both the parties. The matter has to be transferred. Both the matters have to be transferred to the family court at Bangalore. In that view of the matter, the petition filed by the wife, that is CP number 357 of CP number 250 of 2024 is dismissed, and the petition filed by the husband that is CP number 340 of 2024 is allowed. And the pending MC on the file of the court at Davangere,
Man,
that's it.
he says, your lordship, there's a job is not permanent job here. It's a temporary job.
And my parents are residing in Davangere only, and all the other cases are in Davangere itself. There are no boys in my family.
You have an advocate, you tell him.
So temporary job she is having now.
No, the way the whole conduct it is, that's how it is filed. That the court has taken care of it.
I think-
The so and so. The MC number 134 of 2024, pending on the file of the Family Court Davangere is withdrawn and transferred to the third additional judge Family Court, where MC number 1162 of 2024 filed by the husband seeking divorce is pending accordingly. The CP number 340 of 2024 is allowed.
Number 3, Chandrana HB for petitioner, Narayan Swamy.
This case appear for the petitioner, my lords. This is petition, my lords, seeking transfer of the OS petition filed by the husband, my lords, seeking divorce to Bangalore, my lords.
From where to where?
Chintamani to Bangalore, my lords.
Chintamani to Bangalore. What is the distance?
Around 70 to 80 kilometers. my lord.
Which year is the MC?
My lord, MC, they filed the OS, my lords, seeking
OS
divorce.
what?
Seeking divorce, my lord.
When is the OS filed?
The OS was filed in the year, my lords. 19/7/2024, my lords.
19/7/2024.
19/7/2024. My lord, after that, my lords, a petition came to be filed, my lord, by the wife petitioner, my lords, in Domestic Violence Act before the Bangalore court, MMTC, my lords.
What do you say?
This case appear for respondent. Prior to that, matter, the respondent to file the voice in voice petition at Chintamani, madam. Now, and after that, the petitioner is filed a Domestic Violence Act petition against the respondent. Same is pending before the 6th MF.
That's what he also said.
Yes, madam. Only to arrest the
They have appeared before the trial court also, my lords, here in Bangalore.
appear, madam.
Before that,
mention-
my lord, there was a FIR also registered
The
before Chintamani.
petitioner is mentioned the address in permit.
Doing here, what is she doing in
She's
Bangalore?
doing a householding work, my lord. She has a small baby. She was thrown out of the matrimonial house.
She has a baby also.
She was a
What is the
small
baby?
child, around 4 to 5 years. my lord.
Please come.
The petitioner is mentioned in the address in Padra and Pura Bengaluru, madam. It is shown that ಯಾವ documents is not produced before. Documents and produced ಮಾಡಿಲ್ಲ. Some permanent address is Chintamani.
Now she is residing in a temporary house, my lords, in Bangalore. She's doing household job. We have produced the documents before the trial court, my lords. Like,
Please
Yeah.
come. The
CMS has also
petition
been
is filed
registered.
seeking transfer of MC number, transfer of OS number 113 of 2024 pending on the file of the senior civil judge and JMSC Chintamani, Chikballapur district, principal family court at Bangalore, family judge court at Bangalore. It is stated, the facts of the case are the marriage has taken place on 15/11/2019. And in the wedlock, they're blessed with a girl. Blessed with a
girl,
girl,
girl child.
blessed with a girl child who is now aged 4 years. In view of the differences between the parties. The husband has filed OS number 113 of 2024. OS is filed for divorce,
Divorce.
Yours.
seeking divorce. The wife had filed a petition under section 12 of the Domestic Violence Act before the Judicial Magistrate of First Class traffic court 6 at Bangalore. That is criminal miscellaneous number 22 of 2024. It is submitted with the land counsel appearing for the wife that she has been decided, she is working, she is doing household work and eking out her livelihood. It is stated that she has also to take care of the daughter who is aged about 4 years and it's difficult for her to travel all the way to Chintamani, which is 80 kilometers away on each date of hearing. Next parallel, counsel appearing for the respondent husband submits that wife is a permanent resident of Chintamani only for the purpose of, only for harassing the husband. She has filed the petition in Bangalore. Next, having heard the counsels on either side, there is a material on record. With regard to the jurisdiction and with regard to the residence of the wife, already necessary material is placed before the trial court, family court.
Magistrate,
Huh?
MMTC court,
To the
Metropolitan Magistrate.
Metropolitan Magistrate Court, and accordingly the criminal miscellaneous is numbered there. Considering as such, this court is not able to appreciate the submission of the land counsel for the respondent, considering the fact that the wife is has to take care of the girl who is aged 4 years. And the distance is 80 kilometers, considering the convenience of the wife. So this court is passing the following order. So and so pending on the file of so and so is withdrawn and transferred to so and so accordingly allowed.
Case number 4, Muralidharan N for appellant, Pradeep Casey for respondent.
I appear for the appellant, madam.
Yes, what do you say? Yes,
My lordship, there are 3 defenses raised by this appellant hearing. One is the owner of the vehicle has denied the employer and employee relationship between the owner of the vehicle, that is tractor. He has denied the relationship of employer and employee relationship.
no,
between-
first we are on the liability.
Yes, my lord.
On that, what are your submissions?
Yes, my lord. As per section IMT 47, no additional premium has been paid to cover the risk of any such employees who are operating any missions attached to the tools of the tractor. That is primarily one first point, my lord. Even if, assuming for a moment, if your lordship turns to the premium schedule which has been shown in the policy, no additional premium has been paid to cover the risk, madam. As such, I have no liability. That is basic. Apart from that, the respondent number 1, the respondent number 2, who being the owner of the vehicle, who has clearly and categorically denied the employer and employee relationship between him and the owner of the injured at the time of the accident. Another point is, at as per the petition itself, the petitioner has claimed that when the incident happened, the tractor was unattended and it was somewhere else. There was no driver to the tractor. The tractor was running, the driver was not in the seat. Accordingly, the charge sheet has been filed under section 3 read with 191 of MBA. That is second point. On this ground also, I am not liable to pay the compensation. The third point is, the doctor who has deposed 65% disabled to the particular limb, the tribunal has considered 60% disabled to the whole body. As your lordship is 1/3, it must have been taken into consideration. These are the 3 major grounds which I have been agitating before this honorable court.
Yes, with respect to the first contention is concerned, my lord, no separate premium is taken by the insurance company is not correct, madam. Because, my lord, any materials attached to the tractor which cannot run independently, it cannot be treated as a separate vehicle, madam. As per say the section 2 subclass 44 of the Indian Motor Vehicles Act, my lord, it is very much clear that, my lord, that is with respect to the definition of motor vehicle. Definition of motor vehicle.
Subclause 44.
Madam?
You said 2 subclause?
44.
Mm.
44. Given, my lord, any threshold or any compressor or any material attached to the tractor which cannot run independently, it is, they're treated as a motor vehicle within the definition, my lords. And also, my lords, so with respect to the premium is concerned, my lord, since it's considered as a single vehicle, my lord, no separate premium is required. And also, my lord, with respect to IMT 47 is concerned, my lord, as per their own exhibit, my lord, it is very much clear that, my lord, that is a compressor attached to the tractor is covered.
So that is one aspect. What do you say about the other one with regard to the employer-employee relationship?
Employee relationship, my lord, so the respondent number 1 never come into the stepped into the witness box and never examined by the respondent
And
number
based
2.
on what he's saying that he has denied,
No, that is with respect to objections is concerned, my
he
lord.
filed objections denying the relationship.
Yes, ma'am, please, my lord. With
Then
respect to that is concerned, my lord,
He didn't get himself examined.
to substantiate that, my lord, I have also examined one more witnesses, PW3, my lord, who is none other than the worker at the same plant.
Please come to the
PW3.
order.
Reported the case, my lord. It's in Canada,
Judgment, I'm saying about the judgment.
please.
Judgment.
Read from para 11.
The respondent number 2 has contended that on the alleged date, time and place, petitioner was not an employee appointed by the first respondent. There is, or the slash was no relationship between the petitioner and the first respondent as a matter and servant as defined under law. Further contended that the said compressor was not insured with respondent number 2 and only tractor was insured with respondent number 2. Further, the respondent number 1 has violated the policy conditions as is the second respondent is not liable to pay any compensation to the petitioner. The opposite arguments of the respondent number 2 will not hold good for the reason that it is the duty of the respondent number 1 to prove that there was no employer and employee relationship between the respondent number 1 and the petitioner. The respondent number 1 has not stepped into the witness box to prove her contention. Just filing written statement is not sufficient to discharge their burden. Then, the second contention of the respondent number 2 also will not hold good for the reason that it is mentioned in the insurance policy, that is Exhibit R2 IMT 47, that is a drilling rigs attached to the tractor. Therefore, second respondent has taken the premium, including compressor. Under such circumstances, the insurance company is liable to compensate the petitioner. Hence, it has to be presumed that the first respondent has admitted the case of the petitioner that he was working as a compressor operator since 7 years under first respondent, and he sustained injuries when he was working as a compressor operator. Respondent number 2, though it has denied the case of the petitioner, nothing has been elicited in the cross-examination of PW1 to disprove the case of the petitioner. Though there is rebuttal evidence from the insurance company, it has failed to prove its contentions. Hence, I feel the oral evidence of PW1 is sufficient to hold it. The petitioner was working under the respondent number 1 as a driver. I continue, Miller.
Is that workman compensation? And what do you say about the disability aspect?
With respect to disability is concerned, Millard said it's a permanent functional disability. Such being the case, Millard, disability had to have been taken 100%, Millard. That is, which is considered 65% only. Since we are not preferred any appeal, Millard, that is correct. A clear case of amputation, Millard. Completely, I have lost my right hand. The tribunal had to have taken 100%, Millard. With respect to functional disability is concerned.
Yes, 41B.
Yes, ma'am.
41B of the workman compensation Act.
So,
Please, ma'am.
My Lordship, with regard to the disability is concerned, your Lordship may kindly turn to the deposition of the PW doctor, PW 3,
Yes.
wherein he has categorically and specifically stated that the disability is. Sir, one second. Chief examination, my lord. The petitioner has a permanent disability of
The nature of injuries that you please tell the court.
crush amputation of the left hand, level of wrist, my lord. Wrist. Left hand.
You
Yeah.
can't consider it as a, listening to the, only to the limb.
lord.
Disability to the whole body.
My lord, he's
That's-
expert
that's-
doctor, my lord.
I see.
You may kindly see 65% for his left upper limb function,
Yes.
man. That's what he has said.
He's a mechanic. The, I agree with the orders passed. when he said
Compression
that,
operator.
PA number 2 of it, 3 of 2014 dated 15 June 2019. The insurance company is before this court.
My-
The claim petition
I'm
is.
sorry for the interruption. I would like to submit two citations in the court of my defense. My lord, you may kindly, there is this Gadi Lingappa case, my lord, wherein the full bench of the Honorable High Court has clearly held that whether such persons require, the liability of such persons are required to be covered under section 147. Statutory insurance policy is in respect of the tractor crushing machine or plowing machine or any other instruments attached to the tractor cannot be considered by attachment to the tractor so as to cover the risk of person sitting on it, my lord. Para 34 and 35 is the relevant portion of discussions made by the Honorable full bench of this Honorable Court. May be permitted to read, my lord. The question numbers 2 and 3 relate to the persons who are working either on the plowing or crushing machines or any other instruments or equipments attached to the tractor. The question whether they can be construed as an employee so as to
You need
cover.
a copy of it, you have it?
We'll continue. The question whether they can be construed as employees so as to cover their risk statutorily under section 147 of MBA. Considering the definition of the trailer, which we have already quoted above, a plowing or a crushing machine attached to the tractor is not a trailer. The definition semi-trailer contained under subsection 39 of section 2 makes it very clear that semi-trailer is not a trailer. A semi-trailer means vehicle not mechanically propelled other than the trailer, which is intended to be connected to a motor vehicle and which so constructed that a portion of its superimposed on and a part of those weight is borne by that motor vehicle. Therefore, every instrument, including plowing or crushing machines attached to a tractor, will not be necessary be a trailer. At highest, it can be semi-trailer. Even assuming that the said two categories of equipments are semi-trailers, the same are not a motor vehicle covered by subsection 28 of section 2 of the MV Act. Since a semi-trailer is not a motor vehicle, the provisions of section 147 of the MV Act will not apply it. Chapter 11 deals with the insurance motor vehicles and therefore even the provision of section 147 of the MV Act deals with insurance of motor vehicles. Even assuming that it is an attachment to the tractor, it is not required to be covered by a statutory policy of an insurance. As such, attachments are not motor vehicles. In view of subsection A to C of class 1 of proviso to subsection 1 of section 147 of MV Act, the liability of the employees working on such instruments like plowing or crushing machines attached to the tractor is not required to be covered by the policy. The insurance in respect of the tractor issued in terms of subsection 1, section 147 of the MV Act. Therefore, for the foregoing reasons, both the question numbers 2 and 3 will have to be answered negatively. Hence, we answer in reference as under. Question number 1 is answered in the terms of paragraphs 23 to 33. Question numbers 2 and 3 are answered in a negative. Question number 4 need not to be answered separately in view of our answer to the questions numbers 1 to 2, 1 to 3, it stands answered. All the pending appeals, cross objections arising out of the group of appeals shall be placed therefore concerned benches having proceeded
Yes.
to consider. This is the findings of the matter.
Yes, third.
My lord, one more submission, madam. Sorry. There is the insured who has appeared before this tribunal. He is assuming for amount even when he is not following the terms and conditions of the policy and entrusted the vehicle to the driver. When he himself has attended, there is a recent judgment of the Honorable High Court of
How
Karnataka.
is that relevant in this facts of the case?
Pardon me?
How is it relevant to the facts of this case?
Madam, my lordship, the charge sheet has been filed under section 3 read with 191. At the time of the accident, the driver of the vehicle means he was not at all in the picture, my lord. The petition which has been filed by the applicant itself, he clearly and categorically contended that at the time of the incident, the vehicle was unattended. There was no driver in the tractor, my lord. As such, the charge sheet has been filed under section 3 read with 181. On the ground also, I am not liable to pay the compensation, my lord. There is recent judgment of the Honorable High Court of Karnataka, where their lordship, Pradeep Singh, I would like to read out the relevant para, my lord. Para number 5 of the judgment.
Yes.
Para 5 of the judgment.
Yes.
No copy. Missed out one more.
Yes, we'll look into and pass orders. Reserve, next part.
Question number 5. Raju.
Respondent.
Ahmad, B.B. Raju, the respondent.
The claim petition has been dismissed on the premise that the involvement is not proved. We have examined one officer and the MLC extract is produced. It appears that the rider of the scooter, who is the claimant, was intoxicated. On that basis, the claim petition has been dismissed.
There is that proceedings here. Proceedings, please.
I'm sorry, last occasion I wasn't present.
No. On 13 to 2025, there was no representation. On behalf of the appellant, again on 6/3/2025 also, there is no representation. And some matter was directed to be restricted and the capital for dismissal. Today also there is no representation. Accordingly, dismiss the non-prosecution.
Question number
Yes, next.
6. Patel D. Karegowda.
Yes.
I pay for the second rest.
For responding.
Liability has been fixed on the owner of the vehicle.
How many insurance companies are there?
Two insurance company, 2 vehicles has been involved in the accident.
What are the 2 vehicles?
Tempo and bus.
Tempo and bus. Tempo is insured by whom?
Issued by.
Fourth respondent, Oriental Insurance,
He is appearing.
please.
Oh,
Bus is insured with us,
you are second respondent.
please.
Yes, how the accident has happened?
Diseased was traveling in the tempo.
Oh.
Bus hit the tempo behind the back.
Oh.
The tribunal has proceeded on the ground that they are the gratuitous passengers. And therefore, the owner has to pay the compensation.
Owner is liable.
Owner is held liable.
Hmm.
I have examined 2 independent witnesses those who are traveled in the bus, they have categorically stated before court that the bus was rash and negligent manner, hit the tempo behind the back. Therefore, two vehicles has been involved in the accident. In view of the Appellate Court judgment, in any case,
Yes,
insurance company of the bus has to pay the compensation.
where is the judgment?
I'm not bringing that judgment, another judgment, I am arguing in two folds, man. Even assuming that they are like associate taxes. In 2004, after amendment to the Motor Vehicles Act 1994, when compulsory insurance has been introduced, the insurance company cannot absolve from paying the compensation. It is held. 2004, two SEC.
No, you're claiming compensation against the bus and the insurer of the bus, owner and insurer of the bus.
Because the negligence on the part of the bus only.
Hmm.
They are hit behind the back.
Yes, what do you say?
Please. Where the complaint was lodged. According to the complaint, my lord, the rash and negligence on the part of the pickup van.
On the part of the tempo.
Please.
Hmm.
On the investigation, charges were filed against the pickup van. There is no allegation against the bus regarding the rash and negligence. He came on the right side of the road and dashed against my vehicle on the next spot.
Oh, let it be anybody's negligence. Who hit who? Which vehicle hit which vehicle?
That's what meant. The tempo traveler came on the right side of the road and dashed against the insured bus. What the PW2 and
Came to
PW
the right side of the road means
on
they are
the
going
left
the
side
same
of
way.
the bus. The bus was going on the.
He's overtaking the bus.
No.
Oh.
Coming according to them, there is a twofold of the version their evidence was given. They say that the bus came from behind and dashed against the tempo pickup van.
Hmm.
The other portion, my lord, it is an head-on collision. If the head-on collision, my lord, the tempo travel the pickup van was damaged on the left side of the
Not collision, it would be on the, it could be either ways.
That's what. No, they have the PW2 and PW3. They are not the eyewitness to the accident. They have not produced any document. What they say, contrary to the complaint, they say that the vehicle came from behind. But according to the police document and the complaint and the investigation, the tempo track or the pickup van came to the wrong side of the road and dashed against the bus. Basing on that, Malad, the court has observed that the entire negligence on the part of the pickup van. May permitted to read the para 14 and 13 of the judgment, where court has observed the things.
Then what did the court say? That it's a negligence on the part of the driver of the pickup van.
Yes.
And what about these people? They're traveling in that.
They are traveling in the tempo, not in the insured bus.
Yes. No.
There is no negligence. There is no negligence on my part, my lord. Therefore, the court has dismissed the claim petition against the insured and the insurer of the bus.
That tempo is insured by them.
With the fourth.
Then what is the finding of the court on that?
Fourth respondent, it is a goods vehicle. The vehicle.
So you're saying it's a pickup van?
No. Pickup van, the court has observed, they have produced the policy particulars before the court according to it's a goods vehicle. Therefore, in a goods vehicle, in a goods vehicle, passengers are not there. They are going to attend some marriage.
How many are there in that?
2 persons per day.
And then as the owner of the goods, they can't travel.
Pardon?
owner of the goods, they can't travel. In a goods.
They are not the owner. They have
What is-
specifically stated that in order to attend the marriage, they are. That is the reason when the claim petition was
And he's relying on some judgment. What is that judgment?
Which?
Just now he said some judgment of the Supreme Court.
Baljeet Kaur versus National Insurance Company. 2004.
Baljeet Kaur.
Ah, yes, Baljeet Kaur.
Baljeet Kaur is with regard to.
Yeah, they are in that case, that he has traveled in a truck. The Supreme Court has held that pay and recovery order has been
Pay and
made.
recoveries in the light of the law in Asha, what is that, Asha
Asha
Ran's case? And where they had already some order to their benefit, in view of the changed circumstances, they should not be put to any inconvenience.
Yes.
That pay and recover was ordered.
In 2004 itself, they have categorically stated, after amendment to the Motor Vehicles Act in 1994, when compulsory insurance has been made, it has been insured with the insurance company. Therefore, insurance company has to pay the compensation and recover from the owner. In lower case. We can't, and moreover, we will become third parties to the bus, which has been hit behind the back.
Provided the evidence on record discloses that it is
Yes.
because of the negligence on the part of the party.
Negligence, so far as negligence is concerned, under Motor Vehicles Act, there is no provision at all with regard to the negligence. Where is the provision under Motor Vehicles Act? If there is any negligence on the part of the victim, either the victim nor the victims of the LRs of the victims are not entitled for compensation. That is not the intention of the legislature, parliament. It has made clear.
Negligence on the part of the driver of the.
Yes, it intersect. If both two vehicles has been involved, it is intersect negligence.
Yes.
Either they have to pay, either the bus insurance company has to pay the compensation and recover from the pickup van owner. Otherwise, pickup van insurance company has to pay the compensation.
The judgment. Yes. 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 That note is there, no? Small note, that also. Yes,
Therefore, we have become third parties.
yes,
We cannot be denied compensation.
yes. Now let's go to the judgment. Relevant paras will read.
Para 14,
Yes,
exhibit P1, the certified copy of the FIR, kind number
1 minute.
the Karnataka police along with the complaint. Exhibit P2 is certified copy of the charge sheet filed by the police. In the said case, so and so, which in respect of the accident in question, the same is not disputed. Both FIR as well as the charge sheet, allegation made against the driver of the tempo tracks bearing number so and so, driving the vehicle in a rash and negligent manner and causing the accident. Both the complaint as well as the charge sheet shows that the tempo driver who was driving the vehicle in a rash and negligent manner, in order to avoid the dash against his vehicle to the bus coming from the opposite side, took the left cut of his vehicle, due to which the door portion of the tempo tracks dash against the right side front bumper of edge of the bus, the accident car. The claimant who has produced these two documents in the support of they were stated that allegation made in the charge sheet showing the wrong and the accident has been caused. Otherwise, no other whisper has been come to their evidence. Therefore, the evidence of PW1 and PW2 was admittedly are not the eyewitness to the accident is contrary to all the documents produced exhibit P1 and P2. Since the evidence of PW3 and PW are not the trustworthy, same they have not confirmed with the document of exhibit P1 and P2. In their evidence, the evidence of the two person would not be helpful to the claimant. Further, the document produced by the claimant themselves, that is exhibit P5, which is motor vehicle accident report, shows that
accident was not due to any mechanical defect of either of the vehicle. The sense offense of sketch which was exhibit says the inquest Panchanama is at exhibit P4 and P37 shows that Panchas have opined that the accident has occurred only by the rash and negligent driving of the tempo track, which was a vehicle, but not of the bus. The sketch of the vehicle, the accident which is at the exhibit P say produced by the claimant without stating that the said sketch is incorrect, also shows that the accident has taken place on the right side of the road from the direction of the tempo tracks in movement and at the left side of the road of the direction of movement of the bus. The sketch also shows that tempo vehicle as moderated jig or some correction was made, the zigzag manner driving the zigzag manner before the accident and after dash the bus has gone further stop on the left side of the road. The diagram coupled with by the statement of recorded during request Panchanama shows that the accident was occurred solely due to rash and negligent driving of the vehicle by its driver, but not on the fault of the driver of the bus. In this regard, decision they have relied upon the decision of the judge, some judgment, my lord. In case they have referred the Supreme Court judgment where the court has held that penalty basing on those documents. It is very clear it is a negligence on the part of the driver of the bus. Page 17, my lord, 15. In the instant case, also police reports relied upon submitted by the petitioner themselves goes to show that accident has occurred solely due to rash and
The
negligence.
appellants are only on liability or on on enhancement also?
Enhancement also, my lord. Cases.
Let's see the enhancement.
Yes.
First, there are two MVCs. The first,
2009 accident, my lord.
no, the first, there are two MFA 8753 and 8754. 8753 is arising out of
315 of
MVC 315 and the other is 316.
please.
Now first see, let's see MVC number 315. What is the age of the deceased?
Age of 35 years, my lord.
35 years. Who are the dependents?
Wife. 315, my lord, it is stated that.
Got some difficulty, my lord. I could not able to, so the eye drops has been applied.
Then we'll have it on Tuesday.
It can be, he can assist my lord, that's fine.
He also has
Sir.
to look at it.
Caste rate is not available, my lord, that's the reason.
Tuesday, we'll pass the orders on
Tuesday.
Tuesday. Moses matter is parted on Tuesday. We
Get
delete
the
from
copy.
caption for discussion.
Well, I appear for both respondent.
Yes,
You-
we'll hear it on that day.
my lord,
Please.
judgment is out.
Huh?
Judgment, now he has given the judgment, I will assist.
Yes.
In 315, lord, wife and the son of the deceased,
Oh.
and the father of the deceased.
Wife,
Wife, father of the deceased.
wife and father of the deceased. There are two
Please.
dependents.
Please,
Income according to him,
according to him, them, my lord, 8,000.
8,000 is earning.
Please,
How much the court had taken?
4,500 is taken in both cases.
4,500. Accident is of the year
7/6/2009.
2009. Then we'll take 5,000. So 5,000 future prospects at,
Was not granted that.
at how much?
40%,
40%. That is another 2,000.
please.
Then it comes to 7,000. How much has to be deducted towards,
One third.
1/3? It comes to 2,330. And his income is 4,667 into 12. What's the multiplier?
16 multiplied.
Comes to 8,96,000 loss of dependency. 8,96,064. Consortium. 88,000. Funeral expenses, 36,000. Any medical expenses in this?
No, ma'am.
Legal expenses, 10,000. It comes to 10,30,064. And
Sir, oh my, yes, sir.
14,000.
It is lot of disturbances to the court all proceedings in your, from your officer whenever you are unmuted.
Insurance company.
so, what was the amount granted by the court?
6,14,850.
6 lakhs.
14,850.
Now we'll go to the next one. MFA 8754.
Please. In this case also not what is taken. There are
316 of right.
wife, son, and daughter.
I think the court has considered only the wife.
But correct.
What is their age or their respective ages?
That may not be correct, minute they have to take because 18 years and 16 years.
Why the court has not taken? Let's see that. Let us read that.
The lordship kindly cast title itself.
No. Let's just see the finding. Why the
I have
court-
seen minute, but
on what
they say minute, earlier minute, court was not taken very seriously on this point. And they said that if he attained 18 years minute, he is major, so
That's why we look at it. That particular finding.
not liable. Three one six minute.
Seized for age.
Para 38, page 38, last 3 line, madam. So
30?
far as the amount granted share up so and so, since the minor 316 concern, since the entire amount going to her share, deposit bank so and so.
You're reading where?
In the page number 30.
What is the internal, that running page of the judgment?
Judgment also in page 38, Malad,
Hmm.
Orders portion only they have observed is age of a major
Deposit ಬಗ್ಗೆ ಎಲ್ಲ.
not properly discussed on this issue. It only they say what they say and not.
No. It is already observed that claimant number 2 in MBC number 316, since being a son of the deceased and has already attained majority in his.
That's what.
He is not a dependent on the deceased and hence he is not entitled. Then who is entitled? Daughter was held to be in.
She is minor.
No, even for mentioning it in the judgment, we need to know what it is.
That may not be the proper manner. They are to consider as a dependent. 18 years completed, that's only.
Act says that all the legal representatives, it does not say major or married. And Apex Court is also held in Birender case. Birender was a national insurance company.
Hmm. How many are the dependents?
Three.
5, daughter and son.
Son.
So if you come to page 21, internal page, running page 21 of the judgment, court only mentions about the son. So the court has considered as far as the,
Wife.
so what is his age?
Whose age, Malik?
In MFA number 8754,
Ah.
that is 316, the deceased age,
Deceased age 35. 37 only they have taken.
37 years. Occupation,
35.
how much is it?
In both the case, Malad, the court has taken 35 years only.
37.
35.
30?
35.
Hmm. And what about the occupation you said?
Coolie. And
Income also same.
Income also same.
they say 8,000, court has taken,
Hmm. So the difference would be in the consortium, I think.
please.
So loss of dependency would also come to this.
Correct.
8,96,064. Consortium. 44 into 3. One lakh 32,000. In this also no medical expenses?
Nobody. At the spot itself they are. In the Obra hospital.
Not required. Common order.
Para 20, they have discussed both the case regarding quantum of compensation.
It comes to 10,74,064.
Okay.
Please. Go. Agreed with orders passed in MEC number 315 and 316 of 2010. MFA. MFA 8753 and MFA number 8754 of 2013 are filed. The tribunal had disposed of the matters by way of a common order. Hence, these two appeals are disposed of by way of a common order. It is the case of the claimants that The claim petitions are filed seeking compensation of an amount of rupees 20 lakhs for the death of the deceased, two in number, in the accident that occurred on 7/6/2009. It is their case that both the deceased
Traveling in the goods vehicle.
Huh?
Traveling in the goods vehicle, tempo.
they have borrowed a maxi pickup motor vehicle, travel from Irkasandra colony to Antaganahalli, Bangalore, in order to attend a marriage function. While they were proceeding on Kottagere so-and-so road at about 1 p.m. near D. Naganahalli, a bus moving from the Baswade side to Kottagere and being driven by the because of the rash and negligent driving of the driver of the bus. When the maxi pickup vehicle took the vehicle towards left side of the road to avoid the accident, the bus dashed to the backside of the maxi pickup vehicle and caused the accident. And because of the accident, the injuries that are sustained, both the deceased have succumbed to the same and died in the hospital on 12/6/2009. It is the case that the claimant in MVC number 315 of 2010 is there are son and wife. In first case, 315, what the dependent?
Wife and father.
Wife and the father of the deceased or the dependents on the deceased. In MVC number 316 of 2010, wife, daughter and son or the dependents. It is their case that the deceased were eking out their livelihood by doing agriculture work, earning an amount of rupees 8,000 per month. And the age of both the deceased is 35 years. When it comes to the liability and the negligence, the tribunal has given a finding that as per the police records, the accident had taken place because of the negligence on the part of the driver of the pickup van. And the said pickup van is a goods vehicle. It is the case of the claimants that they have hired the said vehicle and traveling in the same. As they are the gratuitous passengers, they are not entitled for any compensation from the owner and insurer of the said goods vehicle. When it comes to the bus, as the evidence on record shows that the negligence is on the part of the driver of the pickup van. The court has held that there is no liability to the owner and the insurer of the bus. And accordingly, the court has held that the owner alone is liable to pay the compensation. When it comes to the compensation, the court had taken the income at 4,000 and 4,500 and granted compensation of an amount of
6,14,000.
an amount of rupees 6,14,850 in MVC number 315. And in MVC number 316?
6,11,000.
Lakhs?
11,000.
6,11,000.
6,11,000 was granted, aggrieved thereby. The claimants are before this court. When counsel appearing for the claimant submits that the accident had taken place because of the negligence on the part of the driver of the bus, and the court ought to have the court and the insurer and the owner of the bus are liable to pay the compensation. It is, it is stated that the claim petition is filed seeking compensation both against the owner and insurer of the pickup van, as well as the owner and insurer of the bus. It is submitted that he has examined the witnesses to show that the negligence is on the part of the driver of the bus, which was not considered by the court.
PW 3 and 4, those who are
PW3
traveled in the bus.
PW 3 and 4, who were traveling in the bus, were examined as witnesses. It is submitted that when both the passengers who were traveling have lost their life, they're entitled for compensation, though they were, even if they are gratuitous passengers. He has relied on the judgment of the Honorable Apex Court in Baljeet Kaur's case, reported in so-and-so, and submits that even the principle of pay and recover will apply, and the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle as the claimants or third parties to the insurance policy. It is submitted that when it comes to the compensation, then counsel submitted that the court had failed to grant the future prospects. And when it is the case that is earning 8,000, court ought not to have taken 4,500 as income. Further, even on the conventional heads also, the amount that is granted by the court is on the lower side. When it comes to MBC 316, then counsel submits that the son, though major, is dependent on the father, and the court had not considered the son as a dependent and not granted the amount. It is submitted that the insurance company is liable to pay the compensation, and the insurance company is liable to pay the compensation, and the compensation needs to be enhanced. Next one. Land counsel appearing for the second respondent insurance company, which has insured the bus.
Please.
Which has insured the bus, submits that all the police records clearly reveal that it is because of the rash and negligent driving of the driver of the tempo traveler, the accident had taken, tempo pickup van, the accident had taken place. When the evidence is clear on record to show that there is no negligence on the part of the driver of the bus, question of liability will not arise, and court had rightly considered the same. Next parallel, and counsel appearing for the fourth respondent insurance company, which has insured the goods vehicle, submits that the vehicle involved in the accident is a goods vehicle, and the deceased are not supposed to travel in the same. They are the gratuitous passengers, and it is their case that they have hired the vehicle to go for to attend a marriage. Being the gratuitous passenger, they are not entitled. They are not entitled for any compensation, and in view of the violation of the terms and conditions of the policy, the question of pay and recover will not apply, and he submits that the judgment of the apex court in Baljeet Kaur's case will not apply to the facts and circumstances of this case. Next part.
Having heard the 2018 Kenny's case, it has to be referred. Both two vehicles has been involved. There is a negligence on the part of the both the vehicles.
Composite negligence.
Yes.
Having heard the counsels on either side, produce the material on record. The two vehicles are made, the two vehicles and the owner and insurer of both the vehicles, that is the bus and the tempo or the pickup van, are made respondents to the claim petition. The argument of the counsel that there is a composite negligence he submits that he says that the two vehicles are involved. And there is a negligence on the part of the driver of the bus. And if alternatively, it is also argued that though they are the gratuitous passengers, the principle of pay and recover will apply. On this, both the counts, this court is not able to appreciate the submissions made on behalf of the petitioner. When there is two vehicles are involved, when there is a composite negligence, then the claimant is at liberty to claim compensation, either on one vehicle or not both the vehicles. Now, here, the claimant cannot take the ground of composite negligence, as it is a specific case that it is a negligence on the part of the driver of the bus. And the medical records.
We were pickup van.
No, they say that no, is what is submitting bus,
Is safe, please.
the bus. In that case, the driver of the bus, then the evidence on record is contrary to the submission of the learned counsel. And all the medical records reveal that it is because of the negligence on the part of the pickup driver of the pickup van, the accident had taken place. In that case, the insurance the owner and insurer of the bus are not liable. Then coming to the tempo, which is a goods vehicle, it is the contention of the counsel for the petitioner that the pay and recover principle will apply in the light of the law laid down by the Apex Court in Baljeet Kaur's case. In the said judgment, Honorable Apex Court, while discussing the earlier legal position in view of the law laid down in Asha Rani's case, and where the claimants have already had the benefit of an order where the pay and recover principle was applied, in those particular facts and circumstances, pay and recover was ordered. So there is no it cannot be, there is no precedent with the Honorable Apex Court that in case of gratuitous passengers, the insurance company is liable to pay and recover from the from the owner of the vehicle. As such, even on that count also.
After 1994 amendment to the Motor Vehicles Act, when compulsory insurance has been made, therefore, that has.
This court is not able to appreciate the said submission. In the light of the same, this court is of the view that the trial court had tribunal had rightly held that the owner of the tempo alone is liable to pay the compensation, and rightly exonerated the insurance company. Next, coming to the quantum of compensation. In MFA, in MBC number 315, the age of the victim is, the age of the deceased is 35 years. He has two dependents. And according to the claimants, is earning 8,000 per month. The court had taken 4,500. This accident had taken place in the year 2009. Considering the table, the chart prepared by the Legal Services Authority, the notional income is taken at 5,000. Considering the age of 35, future prospects at 40% would come to 7,000. As he has, there are two dependents, 1/3 has to be deducted towards personal expenses. It comes to 2,333. Then the contribution of the deceased to the family is 4,667 into 12, and the relevant multiplier is 16. The loss of dependency would come to 8,96,064. Consortium for the two dependents, 88,000. Funeral expenses, 36,000. In the light of the law laid down by Mekala in so-and-so, the legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees. The claimants in MBC number 315 are entitled for compensation of an amount of rupees 10,30,064. Accordingly, the appeal is partly allowed by enhancing the compensation from 6,14,850 to 10,30,064, which the insurance company, which the owner of the tempo is liable to pay. Then it comes to MVC number 316. Here also, the age is 35 years, and according to them, the income is 8,000. As in the earlier case, the loss of dependency would come to 8,96,064. In this case, the dependents of the daughter and the son and the wife would had considered only daughter and the wife. The age of the son is 18 years, considering that he is major, and the court decided, the court had observed that he is not the dependent. That cannot be, that finding of the court cannot be sustained. And the dependents have to be considered as 3 in number. If 1/3 is then in that case, the loss of dependency would come to 8,96,064. Consortium 44 into 3, 1,32,000. General expenses 36, and same as per the law laid down in so and so, 10,000. Altogether, the claimants in MVC number 316 are entitled for a compensation of 10,74,064. Accordingly, the appeal is partly allowed, enhancing the compensation from 6,11,000 to 10,74,064, which the owner of the tempo is liable to pay.
Cell number 7, consulted by MD for appellant.
Fourth respondent, my lord.
I appear for my lord, the second respondent.
I am for fourth respondent, my lord.
Case of injury, my lord. The appellant is challenged the liability and enhancement, my lord.
You are questioning the liability.
Liability and enhancement. The petitioner is the pillion rider of the motorcycle. 2 vehicle was involved.
One minute.
Motorcycle,
1 minute.
4 minutes. Case of injury.
It's a case of injury.
Injury.
Hmm.
The
What
petition,
is, first on the ground of liability, what is it? Why the,
liability, my lord, the petitioner is the pillion rider of the motorcycle, my lord. Woman is dashed against, dashed the motorcycle. The petitioner is sustained injury, my lord. The trial court, tribunal only consider the record is not found. Only statement of the complaint, statement was stated that the woman is negligent fraud. The trial court is not page number 7, my lord. Para number 15, liability question. Number 1. Is contention that petitioner is relying upon the only FIR, spot measure, IMU report, and other medical documents admittedly, charge sheet was filed against the petitioner. My lord. The case, criminal case was acquitted. Petitioner on the ground that he was riding on the
so
motorcycle.
you are saying you are a pillion rider?
Yes, ma'am. PW exhibit P1 is the complaint, my lord, pillion rider. The charge sheet against me,
No, you are a rider or a pillion rider?
pillion rider, my lord.
Charge sheet is filed against you,
Against me.
considering that you are the
Police is
rider.
fast, police is partially implicated in the petition on the ground that he was a rider of the motorcycle in question, and due to
You are
his
acquitted saying that you are a pillion rider.
pillion rider. Only on it of the motorcycle on the roadside, so and fell down the sustained injury. Admittedly, a criminal case was registered against the petitioner, but admittedly he was got acquitted the holding trial. After holding trial, the learned counsel for GS Sadasivappa argued that just because the false case was registered against the petitioner, the respondent number 1 and 2 cannot take contention that driver of the car was not responsible of the accident without any basis that the petitioner was riding motorcycle in question and without recording the statement of any person. the police is collusion with the respondent number one registered the false case, but petitioner has placed sufficient material to establish that he was not riding the motorcycle. On the other end of the Rudresh was the rider of the motorcycle. But due to negligence of the driver of the car, accident was occurred. On the other hand, the learned so second respondent Sivana has argued that all the police record and against the
We'll
petitioner.
take it on Wednesday. This is smart on Wednesday.
Cell number 8. Cell number 8, Suresh Latur.
I am for the appellant, my lord.
So also this matter also on Wednesday.
Cell number 9.
Same caption. Ready, 9 years.
9.
For petition, appellate, my lord. I filed application for seeking.
When did you file?
Today, my lord.
Where is that?
Today.
Application, my lord. Seeking.
It is submitted that the petition has filed necessary application for service of notice on R1 and R2. Registry is directed to place the same before the court. This is matter on Tuesday. Yes, next.
Cell number 10. Sumantel Bharadwaj.
No, delete from the caption. Monday under the same caption.
Monday.
Yes, 11.
Cell number 11.
For second
Yes.
respondent.
Yes.
Shrikant Rao for respondent.
Second
Show
respondent.
show the order sheet. On 7/1/2025. There was no representation, and again on 6/3/2025, when the matter came up, even on that day also, there is no representation on behalf of both the parties. And the matter was directed to be listed today under the caption for dismissal. Today also, there is no representation accordingly. It appears that the appellant is not interested to pursue the matter, accordingly dismissed for non-prosecution. Yes, ma'am.
Cell number 12. Chetan B. Non-taking steps.
Yes.
Paper draft was not collected. Paper publication draft was not collected in office. Sorry, fine. Issue fresh draft, I will collect and.
Why have you not taken?
Sorry.
Why we have no other work but to again repeatedly do the same thing. Give that. This court has passed an order. An order was passed on 17/1/2025 permitting the petitioner to take out notice. We have substituted service in Karnataka daily newspaper. No date is mentioned when to be taken. It is submitted that they could not take out. No, there is no problem for you because court has not mentioned the date. You can take. No date is mentioned in the order. As such, it is clarified that the petitioner shall take out paper publication in Kannada Prabha daily, which edition?
Asan edition.
Hasan edition, on or before?
21/3. And
Yes,
year
21.
4/4. 4. 21.
But before 21/3 and the date of mentioning the date of hearing as?
4/4, please.
Yes. Don't ask again. Yes, next 13.
Number 13.
On respondent number 2, my lords. Respondent number 2, appeal memo has not received it, my lord.
Where is the counsel first? No representation, post for dismissal on Monday. Yes, next.
Cell number 14.
Appealing
My
for
lord, I appear for the respondent in this matter, my lord.
Have you filed your objections?
My lord, objections are ready, my lord. I do not have the phone number or the address of the other
What
side.
objections are ready for 2016?
That's
We'll
2000.
say that they're not entitled for the interest for that particular period.
But they have not even bothered to explain why there is a delay of such a long time, my lords. They have received the compensation and there is no explanation why there is delay of 7 years.
He's here. If you're here in the court, you would have given her that.
My colleague is there in the court, my lords. He'll serve a
Tell
copy
your
and-
colleague to serve. Let
Right.
counsel for the respondent submits that the objections are ready and the objections are ready and he'll be serving the same on the counsel for the petitioner during the course of the day. Let's this matter next week, not next week. Let's this matter on 25th of April, March. Yes, next.
Cell number 15.
My lord, I appear for the appellant.
My
In
lord,
MF
my lord,
50
I am producing memo to dispense the service of notice to respondent number 2 and 3, my lord,
Representing him.
because
You're representing whom?
appellants, my lord, claimant.
Appellant is Mr. O. Mahesh, no?
Lord, I am seeking, my lord, substituted service to R5, the owner of the vehicle.
AKCR in connected matter, my lord. In MFA
First
916,
hear him. So I have 1 of 24. Where is it? I number 1 of 24 is filed. Substituted service of notice on to R5.
R5,
In Inadu newspaper,
Andhra Pradesh.
no, you said Telangana.
Yeah.
Where is
Telangana.
Where is the person staying?
Telangana.
Telangana is not a place.
Yeah, I'll just, my lord, 1 minute. Lord, Hayat Nagar.
Yes,
KV Auto Nagar, Bagh Hayat Nagar, KV Reddy, Telangana, Andhra Pradesh.
the petitioner permitted for notice in Inadu, Hyderabad, Hayat Nagar, edition, on or before,
Before 21.
mentioning the date of hearing as 4/4. Please make that correction.
Well, a little longer time, my lord, because it has to go to the neighboring state for publication.
No, you cannot, because Telangana, there is nothing like Telangana is the name of the state.
Yeah, yes.
Hayat Nagar is in Hyderabad.
Yeah.
So Hyderabad Hayat Nagar local paper. That's how it should be.
Yeah. No, I'm only seeking for longer date, my lord, for publication.
You want a longer date.
Yeah.
Then what
It
is
has
that?
to be sent from Bangalore to.
Yes. 28/3.
Please, ma'am.
28/3 mentioning the date of hearing as 11/4.
11/4.
And then counsel for the petitioner shall make the necessary changes.
Please.
Yes.
Cell number 16.
Yes, you're saying something 15.1.
your lordship, in connected matter in MFA 916 of 2018, I am producing the memo to dispense the service of notice to respondent number 2 and
In 15.1. A memo is filed by the counsel for the appellant seeking dispensation of notice to R2 and R3. The memo is taken on record and the notice is dispensed with at the risk of appellant. The notice to R1, R2 and R3. Yes, next.
Cell number 16.
Some for appellant.
What is happening? Where is Mr. Shivanagowda?
Sharat Gowda, BC Shivanya Gowda, for respondent.
Counsel for the petition is present, no representation for the respondents. Finally, this is matter on Tuesday. Yes, next.
Lords, I seek for Wednesday, my lords. Wednesday, my lords. 12th.
What?
12th, my lords.
12.
Please.
Yes.
List number 2, cell number 1, Prasad B.
Petitioners, my lord.
Petitioner.
Actually, the party has not come up, my lords, and I apologize for yesterday, like I couldn't come up for by the time I reached here, it was already called out. my
Yes,
lords. And for the substitute regarding that also, we have discussed with the party before, but now party has not come up, my lord. So kindly, I need some 1 week of time, my lords, kindly,
You have stay in this,
my lords.
stay interim order.
Interim order is there, my lords.
And if
Kindly
your client has interim order, your client will never turn up. What to do? We just can't.
Even the
keep
trial
on-
court advocate also, my lord, like we have served a copy, but the acknowledgement went missing. Now their intention is
Then
not
we'll do one
collecting.
thing. Why don't you take out notice on the counsel appearing for the respondent before the trial court? That is better. There is no counsel for the respondent.
For the respondent is there, my lord, in the trial court, what has happened is, like, they have received the copy, it's been served already, but the acknowledgement went missing, my lords.
No, do
from
take
our
it again instead of substituted service.
But when I try to approach them, what they're telling is like, I need to contact my party, like both the parties are not cooperating properly. Like from from their trial court advocate also
They don't
responding.
have, they have no interest to pursue the matter, we'll dismiss it.
No, my lords, kindly, 1 week time is needed, my
Maximum
lords,
a
then.
week, not
1
more
week.
than
Yes,
that.
my lords, kindly.
This is matter on Wednesday. By the time if the necessary application for substituted service is not filed, the petition will be dismissed on the ground. This is a transfer petition of the year 2022. The petitioner, having obtained stay of all further proceedings, is not even taking steps to serve the notice on the respondent. Release from the caption dismissal. Next.
Cell number 2.
Appear for the petitioner in this matter, my lords.
Sir.
I'm not, I'm really sorry, my lords. Yesterday I was
Yes, sir.
not present before this honorable court.
What is
Moment.
Wakalat not filed? Why his name is coming on the list?
My lords, it was actually, he is a counsel appearing for the respondent before the trial court.
You have taken out.
Please, my lord, please, my lord. I submitted
Transfer
the,
from where to where?
my lord, the petitioner is seeking transfer of petition, my lord, from the civil judge senior division court from Kalgatiki, Dharwad district to Sagar, Shumoga district, my lords.
Kalgatti to Shimoga.
Please, Sagar, my lords, Shumoga district, Sagar,
Sagar.
please.
What is the distance between?
My lords, it is around 186 kilometers. And absolutely, there are no direct buses, my lords. She has to change two.
Any issues?
Please, my lords, a daughter.
Aged about?
My lords, the daughter's birth certificate is here, 2019. It is around, my lords, 5 years. And
Please
she has
come.
got a ailing mother also, my lords, who is handicapped.
The present petition is filed seeking transfer of MC number 13 of 2023, pending on the file of the senior civil judge and JMFC Kalgatagi to the court, to the senior civil judge court Sagar. The facts are the marriage between the parties had taken place on 19/7/2018. And in the wedlock, they're blessed with a good daughter on 12/7/2019. In view of the differences between the parties, the respondent has filed a petition under section 9 of the Hindu Marriage Act. In view of the differences between the parties, the wife has started residing along with the parents, and the husband has filed a petition seeking restitution of conjugal rights. That is MC number 13 of 2023 on the file of the senior civil judge and JMFC Kalgatagi. It is submitted by the land counsel for the petitioner wife that the distance between both the places is 186 kilometers. There, she has to take care of the daughter who is aged about 5 years. And also her mother is having, having health issues. And
Disability, my lords. It is a disability. She has got 75% disability.
She has a disability and she has to take care of her mother also. And it's difficult for her to travel. This court, this court has directed the petitioner to take out notice on the counsel appearing before the trial court and file a memo to that effect. He has filed a memo to that effect stating that the notice is served on the counsel, Mr. S.V. Bosley. In spite of service of notice, there is no representation on behalf of the respondent. Hence, this court is proceeding to pass orders on the merits of the matter. Next para, having got the counsel for the petitioner, peruse the material non-record. Considering the fact that the distance between Kalgati and Sagar is 186 kilometers, and the petitioner has to take care of his take care of her daughter and also a mother who is handicapped, considering the inconvenience that's being caused to the petitioner. This court deems it appropriate to allow this petition. Accordingly, the following so-and-so pending it so-and-so is withdrawn and transferred to so-and-so. Accordingly allowed.
Obliged.
Ravisha MG,
Yes, madam. The
Yes.
petition says a transfer petition. The petition is the
And
wife,
is, you're also here? Yes.
Respondent.
Filed by whom?
filed by the wife seeking
To where?
from Maddur Civil Court, Mandya district to Ramnagar Civil Court, Ramnagar district.
What's the distance?
The 52 to 55 kilometers away.
Hmm.
The petitioner, along with his her minor minor daughter, minor son,
Age?
age presently 11 years, 9 years. 9 years.
10 years,
Okay, fine.
What do you say? What do you say?
10 years.
What do you say?
No, she can travel, my lord, because now the Shakti Yojana is also there, only 55 kilometers. Only two
You
stops.
also travel only 55 kilometers.
I will
You can also travel 55 kilometers.
I'm traveling, my lord.
No, we will transfer, then you will travel. Please
No,
come.
there's no difficulty in traveling. That is not a main ground.
No, that's for you. It's for her to say whether there's difficulty or not. The present petition is filed seeking transfer of MC number 82 of 2023, which is pending of the MC is for divorce.
MC for divorce.
MC number 82 of 2023, which is pending on the file of the Senior Civil Judge Madhu to the Senior Civil Judge Ramnagara. The facts are, the marriage has taken place on 3/3/2014. Dharmasthala. And they're blessed with a son on 12/1/2015. In view of the differences between the parties, on 8/5/2022, the wife had made a complaint to the police about the harassment. The respondent has also gave a complaint against the petitioner on February 22, in the month of February 2023. Thereafter, on 19/8/2023, the husband had filed a petition for divorce on the ground of cruelty. That is MC number 82 of 2023. And the wife, that is the petitioner herein, had filed a petition seeking maintenance.
CMIS number 40/20.
And also gave a complaint. Bidari means where is it?
Bidadi.
Biddi is very near to
Ramnagara.
Ramnagar. It's hardly 8 kilometers.
They gave a complaint at Bidari. It is the case of the wife that she has to take care of the son and it's difficult for her to travel 54 kilometers.
55 kilometers.
55 kilometers, and as such sought for the transfer of the pending MC from Madhu to Ramnagar. Land council appearing with the respondent husband submits that the distance is only 55 kilometers, and it's not difficult for the wife to travel. Further, son is also aged about 10 years, and there cannot be any difficulty for her to travel. Next, for having heard the counsels on either side, there is the material on record. The wife is staying along with the parents, with the boy, with the boy who is aged 10 years. And this divorce
Stays with
petition.
her parents. She's not
She
staying
is-
with her parents.
She is residing in an independent rented house.
She's residing at Ramnagar along with the child, and she has to take. care of-
Biddi. She is residing Biddi in rented house.
She is residing in Bidadi in a rented house. And it is difficult for her to travel to Madhu every date of hearing, considering the same. The inconvenience being caused to her, this court deems it appropriate to allow the petition. Accordingly, so and so is withdrawn from so and so. In all these matters, end of it, the wife shall cooperate with the trial and shall not seek for unnecessary adjournments. Accordingly, so and so is withdrawn and transferred to so and so. Yes, next.
Cell number. Cell number 3, 4, 4. Cell number 4. Temparaju,
No representation for dismissal on Tuesday, on Wednesday. Is 5.
cell number 5. Banu Prakash HV for appellant. KR Ramesh.
1 week time may be granted to take steps. Interim admin
It's already held that notice to R9 is sufficient.
is already issued, written. Respondent number 224.
Order is passed, notice to, just look at it. If it is there, it's fine. Otherwise, notice to R9, returned with a postal server refused, wants to deem service of notice. What happened to the earlier notice to R2 and R4?
This is the first time I think.
Huh?
This is the first time I have to go on.
2024.
Second time.
Second time. First time, what happened to the notice?
First time is only written. This is the first time.
For all.
Notice to R2 and R4 for second time. First
Second.
time notice must have been
Written.
Written with what? R1 is
Dead. Their LRC is already on record. I filed a memo.
where is that memo?
Memo is not
Give
there.
that memo.
Tomorrow filing.
The LRs of R1 are
R1 are appellant, R2, 3, 4, 9.
give that memo.
Have you filed the memo, sir?
Otherwise, 1 week time may be granted. I pay the PF is also.
We submitted that the R1 is no more and already the LRs are on record. The petition will come up with a memo. Then in respect to the notice to R2,
3, 4.
R2 to 4, we shall pay the process within a period of 1 week, or else the petition shall, as far as R2 and R4 are concerned, the appeal shall stand dismissed.
Interim admin.
Look at it, if it is there, it's time.
Cell number 6.
I pray for the petitioners in this case, my lord. Lord, I had filed an impleading application along with original powers of attorney as well as the wakalat. Now that impleading application may kindly be allowed, my lord, to bring on additional petitioners in the case.
Regarding memo, affidavit dated, not pressed by advocate for petitioner, what is?
My lord, that was an order is already passed that it's not pressed, my lord.
Then why
But
again?
I had filed 2 memos on the same date, my lord. So one of them can stand as not pressed.
IA number 1 of 24. Now you are pressing on IA number 1 of 24.
Please, my lord, please.
And now, why when already that not pressed, that order is passed, why they are mentioning it here? Look at it, any order is passed? Oh, it should be an order, judicial order. Look at the.
Appearing for the petition.
It is, no such order is passed, Mr. Counsel.
My lord, I had filed that an order
You
may
have
be passed
filed,
as
order
as
is not passed.
It can be considered as not pressed, my lord, because I've refiled the originals on
Who is
30th of
passed?
September.
Memo dated 23, 24 is, do that.
That was where I had filed copies of affidavits, my lord. I've refiled the originals.
What date is that?
23, 24.
23, 24.
Where is IA 1 of 24?
That was filed on 23rd October, my lord.
So please come physically and verify your file. All or nothing to be seen.
My lord, only
This
IA
is
number
matter.
1 to be allowed, my lord.
This matter on Wednesday.
Obliged.
Serial number 7,
At the request of non-counsel the petitioner.
Josna Hudson. 7,
This matter was partially taken up day before yesterday with regard to the office objection which was raised with regard to the movables which was there.
No, what is the relief you're seeking in this petition?
Only for letters of administration.
Hmm.
My lords may kindly look at, there is no difficulty with regard to the other items which are stated. The only difficulty is with regard to number 4, page number 4. The movables which is listed, which is the stocks in the US listed company.
Hmm.
My lords, the office has raised an objection under 228. 228 is not applicable because there is no,
Objection. The objection raised with office is overruled.
if I may assuage the concern of the court, I am seeking a letter of administration only to bind my Indian employer. I am employed with the Indian company and these shares are issued by, stocks are issued in respect of the parent company by virtue of my employer.
We'll have it on Wednesday. This is matter on Wednesday.
Malad,
Office objections are on
after the
Wednesday.
it is only for citation, my lord. Citation may kindly be issued.
Yes,
And the notice to the DC may kindly be dispensed with.
yes.
As I'll be paying the full court fee. And
Yes.
I may be permitted to take in the New Indian Express as well as the
Citation. Yes.
Indian Express and Kannada Prabha.
serial number
Date.
My lords, I may be given 2 weeks time to do it.
Skip something.
21.
Yes,
Matter
right.
is listed on 21st, my lords.
yes. Yes,
Hearing on interlocutory application, serial number 8, PK Manjunath,
My lord, I appear for respondents 1 to 7 and 9 to 13, my lord.
Prakash. That
we have
applic-
2/21 for condoning the delay of 1,575 days. Filing the LR petition. CP of 2018.
It was Sunday.
Interim order is there in this.
Yes, my lord.
Interim order is there.
Interim order is there. Idರಲ್ಲಿ R8 has died
Huh?
and we have filed an application to bring the LRs of this is the R8, my lord. Last week it was listed. They are all been served.
I appear for
All
all.
of them are served.
All of them. IA may kindly be allowed, my lord. IA,
EA be allowed and will be hearing the main CP itself.
please, my lord.
You're ready?
I will amend the matter and next week I will argue the matter.
It can be done at the same time also.
Please, ma'am.
CP of 2018.
18.
This is matter on Wednesday. We'll hear both.
serial number
Please.
9,
Interim order may kindly.
Yes, only till that day, no further adjournments. Yes.
serial number 9, Akash Kumar Gowda,
My lord, I appear for the petitioner, my lord. I made an application for condonation of delay, my lord, CP. And moreover, my lord, MFA has been dismissed for
Use
non-prosecution.
the mic.
My lord, MFA has been dismissed for non-prosecution, my lord. The reason for non-prosecution, my lord, the advocate on record's name was not properly reflected in the cost title. So I made an application for recalling the order, my lord, and I also made an civil petition praying for to prosecute the above appeal as indigent person. So I made an application for condonation of delay in preferring the civil petition.
Delay is
We'll
36
come to the
days.
6 days delay.
IA number 1 of 24 is filed to condone the delay of 36 days in filing the appeal for the reasons stated. The delay is condoned. Yes. Causes matter for reclusion. Yes, ma'am.
serial number 14,
Much obliged.
10,
Lordship, direct to serve copies, sir.
And
Will serve it.
petitions serve the copies on the council appearing for this.
Please, ma'am. Will serve.
serial number 10,
Yes.
I appear for the
Dadam,
Appellate, I have made this application impleading the beneficiary of acquisition as a party to the proceedings, my lord.
Who is the beneficiary?
Beneficiary is the managing director Kaveri Niravari Nigama, my lords.
Who is
And
the council appearing? for that?
Council Bhimaya and Prashant appears.
Bring the name of Mr. Bhimaya
CP petition.
and Mr. Prashant also. List this matter on Tuesday and once they come, then we will.
Please,
serial number 11,
already similar matters have been remanded.
If they come,
Please,
yes.
serial number 11,
Serial number 11. I undertake to file wakalat and objections on behalf of respondent, my lord. Kindly grant 2 weeks time.
Seeking transfer from which place to which place?
KGF to Bangalore, my lordship. It is
The distance.
90 to 100 kilometers, my lordship.
Hmm.
So, and she is now currently she is unemployed, and he has not paid a single maintenance to the petitioner. And he resides, he left the place at their mother's place, and he is residing with his parents. Now he is simultaneously is demanding for the divorce, divorce with alimony. He is asking alimony from the petitioner, my lordship. And so many dowry is also paid. Those are, they hold the documents also. And now he is refusing to join with her. It is the one point has to be perused this honorable court, my lordship. We filed a MC petition 75 for 2021. During the pendency of that petition, he filed another petition for divorce. That is the current petition we are seeking for the transfer.
How can you file?
He filed.
Petition?
The date also I have mentioned, my lordship. During the
I have-
pendency of the same petition.
Notice is served long back.
We made our representation also.
Yesterday, I got, client called me. That's why. I
Ma-
take to file wakalat.
After
Kindly
this
grant 2
matter-
weeks, my lord, just 2 weeks.
This matter on April 7th, by the time the counsel for the respondent shall come up with the objections, if any, inter-alia granted is
Yes, ma'am.
extended.
Problem.
Yes, next.
12,
Next.
Raguramovi, Rangaramovi,
It's the case wife petition, my lord.
P. Sharad Kumar.
Wife petition, transfer from Chandrapatna to Mysore.
Chennai Patna to
Mysore. The respondent is virtually working at Mysore only. Just to give harass the petitioner, he has filed the case at Chandrapatna, that is in Hassan district, my lord. More than 140 kilometers from Mysore to Hassan. And it has to be transferred to Mysore family court.
yes, what do you say?
Next week alone, that's something.
What next week?
He is very much working there. The
Hindu Marriage Act, section 21,
What it says?
power to transfer the petition, certain case. Where are the petition under section, this is the, has been presented district court. Having the
The
jury,
concurrent jurisdiction, they can come here also, that's not a problem.
no, madam, Nanjangud, two cases, first cases, respondent filed by Nanjangud. Another cases, petitioner filed by Mysore.
In spite of that, we'll have.
20 kilometer, Nanjangud, Mysore.
no, it's not a different case. Case serial number 12 ಇದು.
On Tollo, Nane,
ಇದು ಚಂದ್ರಾಯಪಟ್ಟಣ ಹಾಸನ್ ಕೇಸ್ ಅಪ್ಪ ಇದು.
Chandrapatna, Hassan, sir.
ನೀವು ನೋಡಿ ಯಾವ್ದಂತ ನೋಡಿ. ನೀವು 17 ನೋಡ್ತಾ ಇದ್ದೀರಿ ಇವ್ರೆ.
Get it.
ಇದು ಡಿಫ್ರೆಂಟ್ ಮ್ಯಾಟರ್.
Okay. Let's this matter on Tuesday at the request of non-counsel respondents. Yes, next.
Serial number 13, Hemant,
For the petitioner, the wife. Seeking transfer from the Chanpatna to Bangalore. Moreover,
Patna to
Bangalore, my lord.
distance.
Distance 60 kilometer. The maintenance case is pending
What are you
before.
doing here?
She is unemployed. He stay with her mother, widow mother, my lord.
Mother stays in Bangalore.
Yes, my lord.
My lordship, the grounds they have taken in the petition, there are only two grounds. The one is the petitioner, the respondent parents have given the lifestyle to the petitioner. But my lordship, they have not given a single document which supports that. And secondly, which she has mentioned that
She is staying in Bangalore. Any dispute on that?
yes, my lordship, she is staying in Bangalore, the respondent is staying in Chenpatna. He is a public servant, my lordship. He is working with the Gram Panchayat Water Service of Chenpatna. If he regularly travels to Bangalore, it may cause inconvenience to the public, my lordship.
Already one, Miss petition is already in Bangalore, madam. Miss petition is also pending in Bangalore.
What petition?
125 CRPC, my lord. And he used to come along, appear through advocate and filed objection. Now the case is posted for orders on IM, my lord. And no difficulty to him, my lord.
The only reason I have appeared before the family court is, my lordship, I was actually afraid of the adverse order. Apart from that, I want this matter to be
No, you're talking about, even the, whatever is the position, wherever the cases are, the person has to go. Yes,
Yes,
please come.
The a family court matter which is in Bangalore, that is okay, which is in Bangalore, but the matter which is before the Chalpatna, that should not be transferred to Bangalore membership. With two matters, again, he has to come for all the hearings. That might cause inconvenience public, my lordship. That's.
Don't worry about the public. Please come. The present petition is filed seeking transfer of MC number 58 of 2024, pending on the file of the senior civil judge in JMCT Channapatna, Ramnagar district, to the senior civil judge in JMFC, to the 5th Additional Family Court, Bangalore. The facts are, the marriage has taken place on 8/6/2014. In view of the differences, the petitioner has left the matrimonial home and staying matrimonial home.
My lordship, I may be granted a permission to file an objection on very short date would be fine. I will file an objection at that.
When did you file your wakalat?
Already taken objection for today.
Lordship, last time when the matter was listed, it was for admission, but they were not present, my lordship.
But today was for objection only, ma'am.
Matter was not. it
Last
may
date
be, my
is
lordship,
taken a
not filed.
adjournment on the ground of to file objection.
There was no representation on your side on 11/2.
Yes, ma'am, but I
Okay.
am not feeling well, that's why
It's okay.
but on that day it's taken a
Not opposed for
adjournment.
her. If this is for the first time it is coming, she should be given an opportunity to file her objections.
Last time is taken for the
She has
same
not
ground.
come up after that.
On the same day, my lord, she taken a adjournment on the ground that she filed the objection.
This is matter on 26th of March
Yes, my lordship.
for filing objection.
The kind commissioner, rule number 12, notice is not in order in this case, he is giving some wrong interpretation made by the other side. Notice is not in order, and I thought on interim order, it's coming up first time for a teacher. Rule number 12.
No, somebody has filed wakalat.
No, it's not in 12, in 17 somebody is telling.
It is there in the cause list. Look at it.
P. Sharat Kumar.
It is there. Wakalat is filed.
And I thought for interim, but yes, they have to travel from Mysore to Kannada.
It's coming up for the first time today. Where is the council? Then we'll have it on Monday. When is it adjourned to now?
7.
Then it will come on Tuesday. That day we'll pass orders. Because he's not here now. Yes.
Serial number 14.
Much of.
Tariqa K for petitioner.
Petitioner, my lord.
Waiting for a week's time to file objection, my lord.
Yes. A week's time for
Interim order may kindly be extended.
Interim order only granted is extended till then. No further time. Yes, next.
Serial number 15. Rajshekara,
Petitioner.
Parmeshwar Proceedings.
My lord, the Bangalore to Mandya zone,
Responded.
the petitioner.
Objection.
I will file the objection. I press time. for
Same, in this
objection.
case also a week's time, finally. If interim order is there, extended till that date.
Serial number 16.
Appear by the respondent.
Proceed.
I'm filing my objections. I've served a copy. Today I have served the copy.
It's time. Land council submits, respondent submits that he has filed his objections today at the request of land council, the petitioner. This is matter after week. Yes, next.
Number 17.
You okay with the date?
Rangaramu.
In this case, appearing for the petitioner.
You are referring to this case.
Please, please, my lord. This is the case in which their contention is because within the district, section 24 is applicable. But the order, section 24 is.
Please forget about it. That contention court is not
ma'am.
considering.
Can be called on Tuesday, man. Along with,
Use along with this 17 and 12 together.
it's all different cases. According
We'll
to,
hear it, we'll hear it on.
please, please.
Yes, next.
Serial number 18.
Well, interim order is there in that case.
In
also.
which one?
17.
Wherever interim order is there, extend. Yes, next.
With the lordship's kind leave.
15.
In the serial number 16, the council is not.
I'm
there
not
in-
available between 12 to 15th, my lords. Any date after that is.
1 week. Date
19th, your particular date, 19th. Yes, next.
Much.
19.
Yes, 18.
Serial number 18. Kalyana.
No representation. This is matter on 16th of April. Don't if interim order is there, also don't extend.
Serial number 19.
Don't extend.
I appeal for the appellate in
Next
this matter.
one. KP Bhuvan,
Here for respondent one.
Objection, Madam.
It's coming up for what? For final hearing?
No, first time notice was issued and interim order was granted. Thereafter, this is the first time it is.
Then we'll hear it finally Tuesday. Just
Interim order may kindly be accepted.
Interim order earlier granted is extended instead of Tuesday, Thursday. Thursday is holiday.
Friday.
Wednesday. Or next, on 17th.
Much.
list number 3. Cell number 1.
I have responded.
Appear for appellate, my lord. Case of injury, my lord, I have only enhancement
Representing Fernando.
for enhancement of the
I'm ready.
Yes, give the fact. You're seeking enhancement.
Yes, ma'am. Date of accident is 28/6/2016, my lord. My main contention is future.
How much you have claimed?
Pardon?
What is the compensation claimed by you?
15 lakhs claimed by me, granted 1,40,100.
1 lakh?
40,100.
And any disability?
Disability, doctor of the opinion, 28% whole body. That is not granted by the court.
Then
Reason also
what
not
is his
mentioned.
income?
Pardon?
Income.
Income, actually coolie. And they were taken into that, not considered that aspect. So 5,500 lok adalat.
Court is considered?
Not considered. The reason also not assigned. It appears it's left out only, not the in the calculations. For what purpose they are not granted, also not mentioned in the judgment. 5,500.
2011.
2011. 28/6/2010.
2010 is
10. 5,500.
10 years.
10.
5,500.
5,500.
Now please come to the discussion.
He was issue number 2, my lord, page number 7. The petition has stated that he had sustained grievous injuries due to the negligence on the part of the rider of the offending vehicle. In this regard, he has relied upon the wound certificate and discharge summary issued by Rajiv Gandhi Hospital, Exhibit P7 and P8. Wound certificate reveals that he had sustained abrasion present over the left scapular area, about 10×4 centimeters, swelling of left foot, and tenderness present over the left foot, and tenderness over the left third to 7 ribs in MAL. Injury 1 and 2 are simple in nature. Injury 3 is stated to be grievous in nature. Discharge summary reveals that he was admitted in the above said hospital from 28/5/2010 to 12/8/2010, 76 days. In hospital, it was diagnosed a blunt injury to the chest and rib fracture, a traumatic and diaphragmatic hernia left. He appears to have taken treatment of blood transfusion and repair of hernia. He got examined the medical record technician, SDS department, Rajiv Gandhi. Next paragraph. The petition has also examined the medical records supervisor, MS Ramaya Hospital, and they have produced IP. Next paragraph, my lord. The petition also examined the Dr. BD Joshi, who I stated to be the retired CMO, Victoria Hospital, Bangalore, and presently working as Sanjeevani Healthcare Center, Bangalore, and consultant surgeon at Kaveri Medical Center, Bellary Road, Bangalore, as PW5. Admittedly, he was not treated the petitioner. He has only assessed the disability of the petitioner. He has seen him firstly on 7/1/2013. He has produced the clinical examination notes, reports, ECG, and X-ray, along with the report Exhibit P19-21. PW5 neither is an orthopedic surgeon or treated.
Adequately granted.
Pardon?
Adequately granted.
20.
How can, no, for the injuries you have sustained, where is the disability? And the doctor, how is he competent, that doctor, to give?
The rib fractures is not in dispute.
It is United.
Now United.
United.
But it's fully, my lord, it's not easy to. 76 days he was inpatient.
In that case, only to this conveyance, attendant nourishment, in that will increase little bit.
Yes.
But not on other counts.
Yes, Your Lordship.
Court was very reasonable in granting. You had one grievous injury, 40,000 is granted.
Accident.
Pain and suffering.
Yes, Your Lordship.
Only future. 8% can be considered, my lord.
Okay, so, and if you want 5,500, loss of earnings also, court has granted how many months? 3
2
months
months
is
as granted, 2 months.
3 months it is granted. It is
4,000 they have taken.
not 4 into 3 is
months.
12.
The 5 months,
Ah.
it's
3 months.
So
Well,
if you
that-
taken 500, 5,000, it would be
5,500.
500, it would be another
1,000.
16,500 would be
Yeah.
the,
Yes.
that we will
My
do.
lord,
Yes,
Medical the loss of earnings, it would be 16,500.
yes,
And towards conveyance, attendant nourishment, we'll increase it by another 15,000.
yes, Your Lordship.
And discomfort and loss of
It
amenities
is also
may be,
10,000 another.
no, because,
Another 10,000 towards.
Yes, Your Lordship.
or another
Yes.
20,000.
No, 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 10,000, United.
Because,
See the, Lordship,
No, if,
after 3 years he has examined the doctor,
Yeah.
doctor has
Maybe-
categorically stated there is
Chief
no,
medical
the
officer, my lord,
fractures
it's
are
not a
united
very-
well.
retired means he's well
The Lordship
experienced.
also
one.
seen that para, that's why.
I have seen.
No, chief medical officer, well experienced,
What
but also my
okay,
lord is
after 3 years,
retired. But it's not a,
uh,
no, I leave to your lord.
usually
I'm
coming
not saying.
doctors will examine.
Now, if there is a possibility, court would grant.
Well, I only admit because the amenities is less, sir, because it is a accident in the year 10. On that count, it is correct. But anyhow, your lordship is hearing on 25. Naturally,
But reason not assigned for that. It's also their future is.
8% interest, we are satisfied also.
Enhanced amount 6%.
Yes, you're right. Delay an idea?
And
It comes to 1,69,500.
Yes, sir.
No, 1,79,000. Legal expenses are not included.
Round about 180.
1,79,500 rounded off to 1,80,000.
Yes, sir.
Achha.
Please come. Agreed with orders passed in MVC number 1617 of 2011, dated 4th March 2013. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs for the injuries sustained by the claimant in the accident. It is a case of the claimant that on 28/6/2016 at about 6:45 AM, when he was traveling as a pillion rider along with his friends in a two-wheeler, when they were proceeding to his Mangamma temple at Narvada, and when they came near the Confidence Group Resort, at that time, the driver of the lorry came at high speed in a rash and negligent manner and dashed against the petition's vehicle from behind. Due to that, he fell down and sustained injuries. According to the doctor, the petitioner has sustained disability at 2%, 25%. The injuries are, there are three, the injuries are,
Injuries are.
the injuries are
Page
abrasion
number
present
7 of
over
the
the left
judgment.
scapular area, about 10 into 4 centimeters. Swelling of it, foot and tenderness present over the left foot, and tenderness over the left third to seventh rib. Injury number 1, 2 are simple, and injury number 3 is a grievous injury. And he has taken treatment. The tribunal on the issue of the negligence has held that the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle, which is insured with the insurance company, and the insurance company is liable to pay the compensation. When it comes to the compensation, the court under the head of pain and suffering granted an amount of rupees 40,000. Towards medical expenses 63,100. And towards loss of earnings, the court had considered the income at 4,000 and granted 12,000. Towards conveyance, attendance and nourishment 15,000. And towards discomfort and loss of amenities 10,000. Total 1,40,100 is granted. The court had disbelieved the evidence of the doctor with regard to the disability, as he is not the treated doctor nor the competent doctor to specify the disability. Agreed thereby, the claimant is before this court. Then counsel appearing for the claimant submits that the court has failed to grant the loss of future earnings and the amounts that are granted on all other counts is not a reasonable compensation. Land counsel submits that he was in hospital for 70 days. 76 days. And the amount that is awarded towards conveyance, attendant and nourishment is on the lower side. Even for the discomfort and loss of amenities as he has a rib injury, the amount that is granted, that is 10,000, is on the lower side. Next parallel, and counsel appearing for the respondent insurance company submits that the accident had taken place in the year 2010. And the compensation that is awarded by the tribunal on all counts is a reasonable one. Court had rightly held that the doctor is not competent to give the certificate, as neither he is a treated doctor nor a competent doctor. Further, he submits that the income was also rightly considered and granted the compensation, and no grounds are made out seeking interference with the well-considered order passed by the tribunal. Next para. Having heard the counsels on either side, peruse the material on record. As per the evidence on record, he has sustained 3 injuries, 2 are simple in nature, 1 is previous injury. The rib fracture, the fracture is also united at the time of, as on the date of the examination. The court had rightly disbelieved the evidence of the doctor with regard to the disability. Then coming to the pain and suffering, the court had rightly granted 40,000 and also medical expenses were granted reasonably. Coming to the loss of earning, this accident had taken place in the year 2010. And as per the chart, the notional income as on that day is 5,500. For 3 months, this court was inclined to grant an amount of 16,500. Coming to conveyance and attendant and nourishment, considering that he is in hospital for a long time, this court is granting 30,000. Then towards discomfort and the amenities of life, another this court is granting 20,000. In the light of the law laid on so and so towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 1,79,500, and the same is rounded off to 1,80,000. The 80,000. Accordingly, the appeal is partly allowed, enhancing the compensation from 1,40,100 to 1,80,000. The enhanced amount shall carry 6% interest.
Much of it.
Yes, next.
2. Cell number 2, Suresh and Latur for appellant, Adinki Shivanand.
For the appellant, madam.
Second respondent. Have you seen that? Have you seen the file?
I saw that, I went through that, Miller. But here, the confusion remains. What they have done is, all the police records are against EH vehicle. Now they have filed, when the police records say that it is EH, now they have proved that we have insured EEA. Now again, the confusion remains, what is the, even the.
Then what is the evidence of your officer?
Our officer is, they have to prove whether which vehicle is involved, because.
They're accepting it. You're accepting it.
Pardon, Miller?
Your officer is accepting the vehicle that is involved.
Yes, Miller, vehicle is involved in the accident in question, 2-wheeler is involved. Now this thing is, the police records say that vehicle number EH is involved in the accident. All the police records, even IMD report.
What your officer says is mistakenly that the other number is shown.
Yes, my lord, EA is shown. Yes, I accept it. EA is shown. Now, they have amended the claim petition saying it is EA. But all the police
No,
records.
here it is like this. You accept there is an accident.
Yes, my lord.
The vehicle that caused the accident is insured with you.
My lord, we have not
Yes.
said that it is a vehicle involved in the accident is insured with us. We are saying that EA is insured.
No, let us see your objections. Did you say so? Let's see. I think basing on your objection, they have changed the number.
Yes.
My lord, what does the police record say, my lord?
Let's see.
The police record.
No,
says
first of all, your written statement should contain all this. Your objection shall contain all this.
Yes.
There are 3 and 4 of the objections, my lord.
Let's see. Yes, you say at para number 3, you have your objection. You don't have? You do one thing, go through all these, or you can,
My lord, my only humble submission is whether what we say is different, my lord. What they say is all the police records say that the vehicle involved in the accident is K04EH9558.
that is insured by you.
Yes, my lord. That is the police records that is speak. Even the IMB report, it is again, I mean, they have inspected EH. And they say that it is damaged.
Then why did you amend it to EA? Mr. Latur,
Yes, my lord. He filed their objections. They have filed objections contending that as per the RC, the vehicle number is EA. The additional objections has been filed by them only, my lord.
additional written statement. Have you seen that? The respondent submits the petition has filed the application to amendment for insertion of the vehicle bearing number K04EA instead of K04EH.
Judgment para 6, page 6 may kindly be perused, my lord.
What does it mean, para 1 and 2? Read para 1 and 2 and tell the court.
Judgment, my lord.
Additional written statement.
Additional written statement, my lord. What I'm saying is, whatever we say.
No, it is like this. According to you, the vehicles are one and the same. There is some mistake in the policy is what you are
Yeah,
saying.
mistake in the policy, my lord.
Mentioning the number
Why is the
you,
mistake in the, this thing, my lord, police record?
because it is never your case that this particular vehicle which is insured by you and the vehicle which met with the, which is responsible for the accident is not one and the same. It is all about that number.
Yes, my lord, that number.
No. If you look at your additional written statement, it's very clear. In so many words, you are saying it.
My lord, even in the evidence, they say that EA had to be insured. By mistake, it is EA has
Anyhow,
been done.
it is for you. Admitted facts need not be proved.
My lord,
You are admitting. You are not denying that.
Lord, the accident is admitted. What I'm saying is accident. is
Accident and
admitted.
vehicle also you are admitted. That's why I'm asking you to look at the additional written statement.
My lord,
When they have filed a petition seeking amendment, for that you have filed the additional written statement. In that, what are you saying is important?
my lord, what time, my submission is.
This respondent submits that the mistake has not only occurred in the petition, but also in the FIR and charge sheet filed with the police. The correct vehicle number, what you're saying is, it's not a different vehicle. A wrong number is mentioned is voice for your case.
My lord, but why?
The
why is
correct,
that
the
police
correct,
record
no,
is-
no, I'll, because you can't improve it. The correct vehicle number.
Millard, I'm not improving
Ah,
on any.
the correct vehicle
statement or
number.
Anything.
No, no,
My
correct.
only confusion is, Millard, I'll make my submission, this day. They have inspected the vehicle. And they have said that it is EH. Why is that number EH is mentioned? They have physically examined.
In the
that
RC number, in RC it is EA.
RC
In all
EA.
other places, it is shown as EH.
Yes, Millard.
Hmm.
Why in the police record it is when they inspect the vehicle?
Because they are not, they have looked at what is mentioned on the vehicle, but the RC carries is, that's not.
Yes, Millard, when the vehicle that is inspected by them shows that it is EH,
Not from the RC.
they don't look to the RC, Millard, when the
No,
vehicle.
no,
when
why
the
are,
physical-
why are you not reading your written statement for a minute to clarify the things? It says, the respondent submits that the mistake has not only occurred in the petition, but also in the FIR and charge sheet filed by the police. The correct vehicle number KA04EA9558 is found only in the RC book. In all other documents, including the insurance policy, the vehicle number is mentioned as KA04. What everybody is saying is, vehicle is KA04EA9558.
Yes, Millard.
But in all other documents, including the document which you have given, even the insurance policy, this number is wrongly mentioned. Vehicle is one and the same. There are no two vehicles. Is your contention?
Millard, yes, Millard, that is the confusion. I agree with that. My only submission is why when the inspector inspected the vehicle, IMB report, why it is saying EH?
No, that is
They
for you.
physically.
That is for you to say. That is for your insurance people to say. Your insurance people are very,
Who has to say? Millard?
very graciously saying that.
The investigation.
Because that's the
officer
whole
has-
difficulty, because that is what it is showing. What is showing is being written in the records. You come up and say, though the number is this, we have insured, we have given a different, by mistakenly that number is shown, but it is the correct number. So the same mistake has happened in the police records also.
My submission is when they see the vehicle, when they physically inspect the vehicle, why they have said KH?
No, you have accepted for that also. Please carry out all these amendments, not only here, in the police records also, please carry out. That is what you said so in your addition written statement. You have not, you know, no, when there is no dispute on that, why should we, what is the business of the court to say something else?
Millard, my only confusion is, this is only a confusion, Millard. Whatever the officers say, she has not seen the accident. I mean, the officer has not seen the accident.
The officer is telling something, basing
It's
on
only
records.
records.
Basing on records, they're saying.
Records, but then why the police, who are the first people who initiate the proceedings, have to say?
No, you are not understanding one simple aspect here. Here it is, though the original number is AH.
Yes.
Original is EA.
Yeah.
In all the records, instead of mentioning EA, it is mentioned as EH.
Why that?
No, because it is mentioned. That's what is admitted by you and everyone. So because it is wrongly mentioned in all the records, the police have also taken it as EH.
Millard, when the complaint says that it is EA.
I think let's not go into that because
My
it is
lord,
very much
owner
clear.
name is
Please
same
come
in
to
all.
please give that.
Owner name is also same, my lord.
Yes, will.
And engine number has been
Yes,
also.
yes. Please come to the order. Now come to liability aspect.
Quantum of compensation, my lord.
So as far as, then come to the compensation. It's a case of
Yes,
death
my
or
lord.
injury.
The accident has taken place on 11/3/2009, my lord.
11/3/2009, yes.
I know notional income is 5,000. The claim of the petitioner is a coolie earning 6,000 per month, my lord. He had sustained the fracture tibia middle 1/3 and lower 1/3 junction and other grievous injuries.
How many fractures?
Tibia middle 1/3 and lower 1/3 junction, my lord. That's
One fracture.
2 fractures.
Yes. Any disability as per
And
the doctor?
there is a permanent disability, 32% of the right lower limb and 16% whole body as per the evidence of doctor, my lord.
If it is 30% to the whole body, how much it will be to the 1/3 of it?
Yes, my lord, but my humble
The doctor
submission, my
might have
lord,
said, but we have to
is
take
a
it like that.
is a coolie. It has directly interfered with the occupation of the petitioner. So that can be taken as 16% as the doctor stated.
We'll take it as 11%.
In view of the in view of the Supreme Court decision, unless there is a rebuttal
So,
evidence, doctor
pain
evidence
and
cannot.
suffering.
Yes,
Doctor is saying on the face of it, contrary to what has been suggested, what is the calculation? Pain and suffering, how much is given by the court?
no, my lord, it is dismissed. It is a dismissed.
Ordered. 2009 acts,
So we'll calculate for pain and suffering 40,000.
2009 accident.
At
that time.
Because he has sustained two fractures. At this time, it will be more than that. Pain and suffering, then medical expense. Now it is like this, as far as this issue is concerned, we can, and if you want all medical expenses and all, then we cannot, this court cannot decide all that now. Or if you want any amount and basing on other, this thing, for example, pain and suffering 40,000, loss of income during laid up period for 3 months, 5 into 3, 15,000. And loss of future income. That is, income is 5,000 for 2009, 5,000 into 12 into, what is the multiplier?
18.
Multiplier will come.
80 into 11 by 100. It will come to 1,18,800. Then loss of amenities 20,000. Attendant, nourishment, and how many days he was in hospital?
11 days from.
You have
11 to
16 days.
26, 3.
How many days?
11/3 to 26, 15 days.
15,000. Legal expenses 10,000. It comes to 2,18,800. Mr. Latho,
Yes, ma'am.
I'll give the dictation later. The insurance company is liable to pay the compensation, and the compensation is an amount of rupees 2,18,800 at 6% interest. Yes, keep this record also along with that. Please keep it. Other matters, give the dates. And give the dates next week.
Should I be present in the afternoon?
Huh? Oh. 4 at the request of land comes for the appellant 2 weeks. Yes.
Serial number 13, my lord.
2
weeks time may be granted.
Why?
Senior not well, my lord, today.
Today is not well. You are asking for 2 weeks.
2 weeks.
This is matter after 2 weeks at the request of land comes for the appellant. Yes, next.
I need not be there. I'll dictate in.
No, I have already, like, I'll dictate it later. Don't have to be there. Yes. Huh? What is that?
Serial number 15, 15. It is already at.
15, at the request of learned counsel, the respondent, 2 weeks' time is granted for filing objections. Yes,
My lord, 16 and 17, my lord.
yes.
Is the court has to hear in the afternoon, I am ready, my lord.
No, all these
A
matters are
a
going
date
to be
may be given
adjourned.
for 16 and
Date you
17.
want?
16 and 17 next week, any date?
19th,
Yes, my lord.
19th, 18 and 19?
18 and 19, I requested to be listed before the CPC on 13th, my lord. I want to examine the witnesses before the CPC on 13th, my lord.
On the 18th and 19th.
18 and
item number
19.
18 and 19. The matter shall be placed before the CPC on
13th of March.
13th of March. Yes.
My lord, resuming my, this next case.
Which
Three.
one?
Number 3, in the serial number 3. List number 3, serial number 3, mine. Yeah. Resuming court in the afternoon,
No.
I'm ready. Give me a short date.
When?
Short account, next week,
Next week on Wednesday?
fine.
Yes.
Public.
That's serial number 5, list number
List number?
3, serial number 5.
Sripad B. Shastri,
BJ Mahesh.
BJ Mahesh, respondent.
When do you want?
Any date?
Give it on Tuesday. 5th on Tuesday, 6. 6.
Serial number 6,
No, I'm saying item number 6. Yes.
serial number 6, Gopal Krishna,
Yes, in this case, my lord.
2 weeks this matter. 7,
7, NS Bhatt,
this also 2 weeks. 8,
serial number 8, Pawan Chandra
weeks,
Shetty,
2 weeks. 9,
serial number 9, Sudhakar B,
2 weeks.
serial number 10,
2 weeks.
serial number 11,
In this case, appear for the appellant, my lord. It's covered by a Supreme Court judgment. Kindly, next date.
First, on
Next week.
Wednesday.
Yes, please, my lord. Much
Yes.
obliged.
serial number 12,
3 weeks.
for 13 urgent, 14 urgent,
Serial number 4.
13, 14,
Hmm.
15.
My lord, serial number 13, my lord, I represent respondent 1, my lord.
It's adjourned. Adjourned. Yes.
Serial number 18 and 19.
No, that's what they want to appear before the CPC. Also, date is given.
Permission of the
Serial
court.
number 4.
List 2, serial 7, citation was ordered. The names of the newspapers may kind. I will.
Serial number 4.
In that, no, paper publication, Indian Express,
Indian Express and Kannada,
Canada,
Bangalore edition.
Bangalore.
Serial number 4.
Serial number?
4.
It's adjourned. 4 is adjourned to when? He just asked for a time.
Serial number 14, second list. Date ಯಾವತ್ತು ಕೊಟ್ರಿ ಮೇಡಮ್?
ಇಲ್ವಾ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಮಧ್ಯಾಹ್ನ?
Update ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಅಲ್ಲ ಆಗಿದೆ, ರಿಸರ್ವ್ ಆಗಿದೆ.
ಅದು date ಕೊಡ್ಬೇಕಲ್ವಾ?
serial number 5 ಏನಾಯ್ತು madam?
Serial 21 ಕೊಟ್ಟಿದ್ದಾರೆ.
Serial number
5 serial number 5.
14. It is on 24th, it is morning only, it is urgent.
Madam, list 2 serial number 5.
ಹೆಸರು ಬರ್ಕೊಟ್ಲೇ ಇಲ್ವಲ್ಲ?
ಅದೇ ಕೊಡ್ತೀನಿ ನಾನು ಬಂದೆ.
Madam.
ಕೊಟ್ಟೆ ನಾನು ತಗೊಳ್ಳಿ.
List
ಏನದು?
ಅದು ಮೆಮೊ ಸೈಟೇಷನ್ ಹೇಳಿದಿರಲ್ಲ.
ನಮ್ಮ ಮೇಡಮ್ ಹೇಳ್ತಾ ಇಲ್ವಲ್ಲ ತಗೊಳ್ಳಿ ಅಂತ.
ತಗೊಳ್ಳಿ ಅಂತಲ್ಲ ಅದು.
ನೀವು ಇವಾಗ
ಮೆನ್ಷನ್ ಮಾಡಿ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Ma'am, ma'am, list 2
ಸಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಇದು ಮಾಡ್ಬೋದು ಅದಕ್ಕೆ.
Ma'am, list 2 serial number 5.
Without the after proceedings, if you are going to produce.
ನಿಮಿಷ.
Madam, list to serial number 14.
ಅಲ್ಲ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಈ ಮಧ್ಯಾಹ್ನ ಸಿಟಿಂಗ್ ಇದೆ
Close.
ಓಕೆ
ಏನು ನಾವು
Court of sir? Court of sir?
Sir, ಹೇಳಿ.
ಡೇಟ್ ಯಾವತ್ತು?
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಮೇಡಮ್?
ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಅರ್ಜೆಂಟ್ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಕರ್ದಾಯ್ತು.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.